to deliberate on this matter, this very important matter. We ask for your wisdom. We ask for guidance. Bless us all. In Jesus' name we pray. Amen.
Thank you. Thank you, MP. Ms. McCarthy, do we have any apologies for absence?
No, Minister, we don't have any apologies.
Okay, thank you.
Apart from Senator Gale having advised us that he would have been late this week.
Okay, fine. Well, he should be with us soon because it's now 9:30 and he said he would be about 9:30. So, colleagues, ladies and gentlemen, good morning. Let me commence by stating our sustained efforts in this committee, that our sustained effort in this committee has brought us to where we are today, which is going through the draft report. We resume from where we left off last week in the report at clause 4. What we have been able to accomplish is to be credited to your diligence and to your unwavering support as committee members, and also the steady guidance of our technical team, the dutiful committee clerk, Hansard writers, IT team, and the Houses of Parliament staff. I wish to remind you that our work in this committee continues to be carried live by PBCJ on cable and online. And I ask that you turn your cameras on whenever you are making your contributions. If you are not able to keep your camera on throughout, please remember to turn it on when you're making your contributions. And so without further delay, let us begin. Ms. Grant, are you going to be sharing the report on the screen like you did last meeting?
Yes, Chair, as soon as I get some co-host privileges.
Okay. And I would like to say to members that I'm hoping that we can complete going through the report today, or to certainly go through most of it. I see, is Senator Donna Scott Motley on?
Yes, Minister, I'm on. Happy birthday to you.
Thank you. And how are you today?
I'm good, Minister. Thank you very much for asking.
Good, good, good. And you know, MP, Dr. Angela Brown-Burke, we share the same birthday.
We almost share it. Mine was yesterday and yours is today.
Yours was yesterday. Okay.
Yes.
So you're on here. Okay,
but
fine.
that's okay. That's okay. We share it.
So, belated happy birthday.
Thank you very much, Minister.
Yes. I don't know if there are any more April born here this morning, but yes. But it's good to see you all.
Happy birthday, Chair, and happy belated birthday to Dr. Angela Brown-Burke.
Thank you.
Thank you, Dwight.
Share the month.
Oh, okay.
I want to wish both of you ladies all the best and many, many, many more beautiful birthdays. Thank
you. Well, happy birthday to all the April born.
Yeah, good month. Very, very good month. That's all who born in April skip around.
Yes. So we're just buying a little time to get the report up so we can
it's up, Minister.
Yes, can you make it a little larger?
It's on 200. You're not seeing it?
Oh, I think it's how they've set this up. But can it go a little larger?
Okay, hold on a minute.
Oh,
Is that large enough?
I should be okay now. Yeah. All right, so we begin at clause 4.
We pick up from there, Minister. So
We
the
pick up from we note.
no, not there. I'm going the next page because of it's this big now. So the next page that I move to, that's where you would pick up.
Where I would pick up, yeah. I would pick up your committee.
Yes, Chair.
Okay, okay, thank you. All right. Your committee also notes the proposal that every employee shall be charged with the responsibility to conduct training sessions for new and existing staff regarding sexual harassment. These training sessions should include role play, scenarios, and examinations, thus allowing employees to identify appropriate behaviors at work and that appropriate behaviors, thus allowing employees to identify appropriate behaviors at work and that appropriate behaviors that are identified in the training sessions can be rectified. Your committee accepts the recommendations, but agrees that provisions would be placed in a schedule along with the policy statement. We're fine with that? Okay, your committee further notes the proposals that the state designs a sexual harassment workplace policy guide or template and mandate that all businesses and institutions utilize this guide to develop their policies. Your committee accepts the recommendations and agrees that a sexual harassment workplace policy guide or template will be included in the schedule to assist as a guide to all businesses and institutions, including small businesses and or those organizations which may not have internal mechanisms. Your committee notes the proposal that clause 43C should be expanded so that the policy statement is also required to state that due process must be exercised when disciplinary measures are taken. Your committee does not accept the recommendations, and now we have to look at this paragraph here that Ms. McCarthy was not sure. We need to finalize this paragraph. Ms. Grant?
Yes, Chair.
Yes, can you assist us here?
Well, Chair, it's for the committee to decide if that is what was decided or not. I don't whatever Mrs. McCarthy has, she would have gotten from the tape.
Yes, yeah.
But I do all that being discussed.
Yes, so members, your committee notes the proposal that clause 43C should be expanded so that the policy statement is also required to state that due process must be exercised when disciplinary measures are taken. Does the committee accept this? Committee members?
I support that, Minister.
All right, so your committee
I agree.
accept the recommendations, yes. All right, so we go on to, your committee notes a proposal that in addition to the duty of the employer or person in charge of an institution to issue a policy statement in keeping with creating an environment free from sexual harassment, there should be appointed in each such organization a designated employee who shall be called the welfare officer, who shall receive training and sensitization on the issue of sexual harassment. This person would be charged with the responsibility of the sensitization campaign within this organization. Your committee does not accept the recommendations, but agrees that rather than a requirement, it should be a recommendation for a person in the organization or institution to be designated as the welfare officer. Okay, clause 4, duty of employer and person in charge of institution to issue policy statement. Go ahead, Ms. Grant. Your committee notes the proposal that the bill should expressly indicate that the policy statement must be issued within a specific time after the act comes into force or following the time of the establishment of a new business. Your committee accepts the recommendation and agrees that the bill should include a timeline for the development of a policy statement in keeping with the phased implementation of the legislation. We also agreed that there would be a transitional period to allow organizations time to get their affairs in order with the assistance of the prepared guidelines. So we agree on that. Clause 4, duty of employer and person in charge of institution to issue policy statement. Ms. Grant?
Yes, Chair, I'm so sorry. There is a comment here that speaks to the timeline that the committee would need to include, need to agree, the committee would need to agree on the timeline for the development of the policy statement.
If I may, Chair, good morning. Happy birthday, Chair. Happy belated birthday.
Thank you.
Senator. And a big shout out to all the Mayborn.
Okay, good.
I
like that.
Yes, Ms. Grant is correct that there was that note, but I think there would also need to be a note for the transitional period as well. I don't recall that that was also agreed. So I'm pointing out that there are two things that I think need to be discussed. And just at the top, that first line, I'm not sure why there are round brackets surrounding the word policy.
Policy.
I think those brackets can be removed.
Can be removed, yes. Expressly indicate that the policy statement must be issued within a specific time. So we have to determine a timeline now. Any recommendations here? SG? You have thoughts here?
The thing is, Chair, the policy statement, I think there would be a template. So once the template is prepared, then it should be easier for businesses, employers to then develop their own. And I was just looking back and I noticed that there is an appointed day notice. So the legislation won't come into effect immediately on gazetting. So there would be some time already given. So I think what the committee would have to consider, though, is that you do have some bigger organizations that may have machinery in place to help to deal with this in a very timely manner, but you may have those other smaller businesses
Yes.
that may need a little more time, even when you provide a template. So I don't know. And this also, my comments are also relevant to this transitional period.
Yes.
So I don't know if you want to look at something like a year.
A year?
At
What
6
about
months to a
6
year.
months?
Those are some of the things you could start looking at, knowing, of course, that this won't take effect immediately on passage of the bill. So you would already have a bit of a delay. But
Yes.
yeah, I think it's left to the committee to decide.
Yeah.
I think I know you have 1 or 2 businesses already that have their own policy.
They do have policy, yes.
Granted, they will now have to review that policy to make sure it accords with what is in this legislation as well. So even those that have something will need to still undertake their own review.
Yes.
So
Yes.
just bear that in mind.
Thank you, SG. Senator Scott Motley.
Thank you, Chair. I believe that it should be about a year. And the appointed date might be close, but I think that we have to take into account the small businesses and the fact that we want this to be implemented across the board.
Mm-hmm.
In the meantime, as a matter of fact, Minister, I think it is very dependent also on your ministry, because we have to have a public education program that sensitizes these businesses, especially the small businesses, to the need to implement this policy. I think that a year would give us adequate time to ensure that everybody has the opportunity to come on board and that this template can be shared with all the different businesses as well. I do know that the unions have been discussing this, and that in many areas, many businesses, large companies, you already have a policy in place. Yes. But I'm not taking into account those with resources. I'm looking at those who might not have. And that is why I'm suggesting a year.
Yes, that sounds reasonable. I'd like to get a comment from Mrs. Coburn Robinson on this. Thank you, Senator Scott Motley.
Thank you, Minister. So I concur with this span of a year, because it could be 6 months to a year, because some persons would be able to complete in 6 months, but a year would allow persons to actually have a chance to develop, because as was rightly pointed out, in some spaces there are small numbers, but the ray of hope is that we have, that's the Bureau of Gender Affairs, we have always been doing our sensitization, sometimes by invitation. We would write to the entity to ask to be allowed to sensitize the staff on sexual harassment, because there might be a gender focal point. That's a person in this space who has been appointed to oversee gender matters. And so when we go into the sensitization, the template is one of the things we discuss. We walk them through how to use it. And if it is that they need perhaps a case study or best practice, somebody who has used it, we have examples of workplaces that have been using their policy statement and have used a template to develop their own policy. So having the gender focal point in place is great. If there's none, what we ask them to do is to identify a focal point or some responsible person who will work with the other members of staff to develop this policy. So yes, I believe the 1 year is good. And to also say we've been doing our sensitization and we will continue to do the sensitization as we progress.
Yes, and in addition to the public education program and the technical support that the Bureau will provide, a year should be sufficient.
Yes, Minister, that's my opinion. I believe a year would be sufficient.
Okay, fine.
You're welcome.
So we agree here on a year. All right. So is this stated in the report? Is this to be stated in the report? Ms. Grant?
Yes, Chair, I believe Mrs. McCarthy is making the notation so she can fix it.
Well, okay, fine. All right, we go to duty of employing person in charge of institution to issue policy statement. Could you move on now with the?
Excuse me, Minister, sorry.
Yes.
Would the 1 year cover the timeline for the policy statement to be developed as well as the transitional period? I remember the SG suggesting that we needed 2 times for.
Yes, that's right. Yeah.
Right. So if I may though, Chair, you see, I was wondering if, to me, the transitional period would deal with existing businesses, accommodations, institutions, and you give them 1 year from the commencement date, from the date the act comes into operation, and where you have a template to get their affairs in order, have a policy statement. But
Yeah.
going forward, I wonder if the issue was that because right now the bill just says you're to have, like, every person is to have a policy statement. So after you give that transitional period of a year, if you have a new business starting up, is it that they should have that policy statement ready to roll as they open their business, or as you open a new school, or is it that you would give them, say, 2 or 3 months within which to period they start their operations to have their policy statement ready?
What do you think would be reasonable? They should have it ready when they start up?
I think they should have it ready.
Yes. Because
the law would have already been in effect.
Yes.
And I think wherever you are going to have every person in charge of an institution, whatever that institution is, if you're starting up your operations, you should have it ready after that transitional period has come to an end.
Yeah,
but that's just my view. That's just my view.
Yes. Senator Campbell Rodriguez.
Morning, colleagues. Happy birthday, Minister.
Thank you, Senator.
I know someone like you find it hard to have birthdays in lockdown time because you're a celebratory person, but we're celebrating with you in heart. And MP Brownberg, happy belated birthday also. Hope you had a fantastic day. On this issue, I agree with Ms. Aldred that at the end of the 1 year grace period, persons coming on board starting new businesses should have the policy statement ready to go. There should not be a grace period for them because you want it to become a part of the culture of setting up a business. And as such, it is one of the things that you have to have ready in order to get going. In terms of the policy statement during that 1 year transition period, I am wondering if they should both fit into that 1 year, or the statement itself should be required earlier so that people become accustomed to that policy statement and its particulars while the transition is taking place. Because if you wait a year for the statement to come out, then there's still going to be a time for the cultural norm to develop. So that's just a suggestion I have pertaining to the policy statement and the transition period.
And any member has a comment on that?
Good morning, Chair.
Good morning.
Oh,
yes. Okay.
Hi, happy birthday
your camera
to you.
On?
I'm driving. It's early morning. I'm gonna go home and get settled.
Okay, fine. Go ahead.
But I just wanted to wish you a happy birthday today, and hope that it's this one will be your best year yet. and likewise the Senator to MP Brownberg. I just wanted to concur with Senator Campbell Rodriguez's approach. I think that with regard to the public relations, the PR component of this, we have to be very strategic in how it will be impacting the culture and the norms of the operations within the society, and especially that it obtains so far-reachingly, from the corner shop right up to into the highest order of business. So I think that it would be imperative that we, as best we can, prepare the population for what is to come, and to educate and inform, and especially around the avenues that persons have for intervention. Thank you, Chair.
Okay, thank you. Dr. Brownberg?
Thank you, Chair. And once again, let me wish you a happy birthday, and thank everybody for the kind belated wishes. I was also thinking, Chair, that the guidelines and the template that would be developed would be a tool that could be used as a part of the public education. And so that we could engage people around what are some of the provisions, what it's asking for, what's it suggesting. And therefore, the earliest time we can have a guideline or a template out so that discussion could start, I believe would be very useful in terms of that part of the public education. Again, because so often the public education that we do sometimes, and then I hear Ms. Rob about the sensitization and institution by institution or business by business, but I think that this is something that's also going to require each business, institution, or accommodation, but also a kind of broader public discussion that begins to get, for it to become even almost a part of our everyday conversation, again, with the hope of changing norms.
Yeah, okay, thank you. Any further comments here? Okay, so what is being recommended here by Senator Campbell Rodriguez is that the statement, you're saying that the statement should be made immediately. Is that what you're recommending?
Yes, Minister, I'm recommending that as soon as possible, the statement be ready. So we not wait until the end of a year.
Well, I think we should possibly allow a little time, however, and you're saying as soon as possible.
Right, which means in my mind, sorry, Minister, but I do agree that there's time needs to be given for it to be prepared. But if we're giving, for example, a year's transition period, the statement should be ready within, say, 4 months, 5 months. That's just my suggestion. Not sure what you think or my colleagues think.
All right. So I would like to get an idea what most of the members feel about this recommendation.
Minister, if I just follow up again, I said earlier that as soon as we could get the statement, the guidelines and stuff that we are going to be putting out there, that would be important as part of the public education. I do believe that the 1 year that we have given takes into account those that don't have the kind of resources. And you're almost looking at those that are probably going to be taking the most time. The fact that we give the year does not mean that there are not going to be a number of establishments, institutions, accommodation, businesses that are going to come, that are going to have their stuff together. As we have said, there are some that are working on it now, some who have it, will have to review it, and I suspect that they will probably have theirs up in a couple of months. But I'm always concerned about those that are going to be most disadvantaged in terms of their ability to conform. And we would encourage them, I'd want to say, to get it done as soon as possible. But I don't think that we should remove the 1 year or shorten the 1 year.
So as soon as possible, but within a year.
Yes, yeah. That's my thinking.
Yes. I think we can work with that, Senator Campbell Rodriguez. as soon as possible, but within a year.
No, because it takes away from the cultural component, where in the sense that it becomes a cultural norm. Because if the transition is a year, what if at the end of the year, especially the smaller businesses, do not have a true understanding of what is to be done? There's no time for them to make corrections. So maybe my 4 months is short, but maybe as soon as possible, within 8 months. So you need a period of time when they prepare and have these ready, and a gap between when that is ready and when the transition period is over, so that they have room for adjustment when they can't get in trouble for that adjustment. So maybe my 4 months is too short, but maybe 8 months then, because you do need to give them that transition period.
Senator Scott Motley, what's your
I must confess, I'm a little confused by this statement, because I thought the reason why we were giving the year transitional period was to ensure that we took all steps possible to assist anybody who might need it. Because as I said previously, there is a sensitivity which is being developed in the public space. Mm-hmm. So for me, how I perceived the 1 year transitional period was that within this time, all businesses would be getting to that stage. I took into account that already there are a number of businesses with a sexual harassment policy. But it was more that we were giving this 1 year because we wanted everyone to come up to speed. So I confess that I'm not very clear on why it is that we want this double time period. And I think that it won't change anything. It won't change anything if we should be just clear from the outset that this is the period within which we are expecting you to be up and ready. So day one after the transitional period, everybody's on the same page. That's my view, ma'am.
Thank you. What I would want to recommend is that we say within a year. And so those who can get the statement out earlier, can get it ready, they do so. You accept that, Senator Campbell Rodriguez? We can work with that? I don't think we should have this delay us that much.
It's not an issue that I'm not willing to just work with what I'm willing to work with what the majority says. I just want us to be cautious that if we set a year, it is something new for many businesses. It is not a cultural norm, and to get people to change behavior within a period of time, I think we need to give them stages. To just say a year, the bigger businesses, of course, are going to respond. They have the resources, they have the mindset, but for smaller businesses, the mindset isn't there. I believe we need like a staircase to get them to that place. And as such, we should give them smaller deadlines within the year to help with the transition. It's just human behavior. That's how you get behavioral change. If you just give them a long deadline towards the end, you're going to have a lot of non-compliance.
Well, SG, can we say within a year? We can, and I see Dr. Brownberg's hand up.
I think that's more for Mrs. Seeley Brown, the drafter, to tell you what sort of language she could assist with.
Thank you, Dr. Brownberg. And then
Sure, Minister, I don't know if I've gotten it wrong. I was thinking that we have set that transitional period to be a year. And that what I was thinking that within that year, as we continue the public education process and all of that, as the Bureau of Gender Affairs assist also with technical expertise and so on, that there'll be some kind of consultation, they'll be reaching out, especially to the smaller businesses and accommodations and so on. And therefore, you know, as we encourage, I'm sorry, when you're doing a draft of this kind, that, you know, there's some kind of iteration going on, and that in fact, the first draft that comes up is not going to be at the end. I don't know if you understand what I'm saying. I'm thinking that it is a process that is being carried out during the year with consultation, with assistance, with technical assistance in coming up with what this statement and the policy looks like.
Yes. Thank you, Dr. Brownberg. Mrs. Celia Brown? How would we?
Morning, Chair, and happy birthday to you, and belated birthday to Dr. Angela Brownberg. Well, let us, we have to be reminded, Chair, that the year is not just to have the policy in place, but it would also be to have all your internal mechanisms established in relation to your disciplinary measures and appointment of your welfare officer, as was proposed earlier, and all of that. So I think we can use language of within a year. So if it is done prior to that time, fine. But by a year after the commencement date comes into effect for the legislation, all these mechanisms will have to be in place. And we have drafted these. These are normal provisions that we draft all the time, Chair, and you can actually sit within a year.
Okay, thank you, Mrs. Celia Brown. All right, so we agree within a year. All right, so I move on now. We note the proposal. Thank you so much. We note the proposal for the use of the term victim at clause 4(3)(h) to be amended so that the provision instead refers to, quote, a statement to the effect that a person who reports an instance or instances of sexual harassment, close quote, or a statement to the effect that a person who makes a complaint of sexual harassment. Your committee accepts the recommendation and agrees to substitute the word complainant for the word victim. We agree that the amended clause 4(3)(h) should now read, a statement to the effect that a person who is a complainant of sexual harassment shall exhaust all internal mechanisms and procedures that are available to the person before making a complaint to the tribunal. Dr. Burke, I see your hand up. You wanted to make a comment?
I'm sorry, that should have been done. I don't.
Okay, fine.
Let me lower it.
Fine. Continue. Your committee also notes the proposal that clause 4(3)(h) needs to be amended or removed to ensure that the highest degree of fairness is achieved. We note further the concern that the internal mechanisms and procedures are to be exhausted before going before the tribunal, which may in certain instances result in employer intimidation due to the power dynamics. Your committee accepts the recommendation to amend the clause on the basis that persons may be victimized or intimidated. We recommend that clause 4(3)(h) be further amended to include the words subject to clause 25(4), thereby allowing persons to approach the tribunal directly where the circumstances so warrant. Agreed? Now, clause 5, duty of employer to take action to deal with sexual harassment. Clause 5 addresses the duty of the employer to take immediate and appropriate action to deal with sexual harassment of a worker, where the employer becomes aware of the sexual harassment. Your committee notes a proposal that clause 5(1) be expanded to also require the employer to take immediate and appropriate action to deal with sexual harassment of a worker, where the employer quotes, receives a report of sexual harassment or witnesses an act of sexual harassment, close quote. Your committee does not accept or accepts the recommendation. So maybe make a decision here, can we? All right. Any comments here? Clause 5, right? All right. We need to make a decision here.
Yes,
Grant?
Chair.
Yes.
Could we just review? Could we just review it ad verbatim again, please, Chair, if you could?
All right. Now, clause 5 addresses the duty of the employer to take immediate and appropriate action to deal with sexual harassment of a worker, where the employer becomes aware of the sexual harassment. Your committee notes the proposal that clause 5.1 to be expanded to also require the employer to take immediate and appropriate action to deal with sexual harassment of a worker, where the employer receives a report of sexual harassment or witnesses an act of sexual harassment. Do we agree here?
This is an act of sexual
Sorry,
harassment.
Chair, I think you should read the rest of it because
rest of it,
it's
yes.
all, yes, because
Yes, could you
it
go
was
ahead?
nuanced, and then I think the committee would then, your members would then have a better idea
That's
of.
right.
Uh,
So in relation to the requirement of the employer to take immediate and appropriate action at clause 5.1, we agree that a provision should be included to give a timeline of 2 days for the employer to notify the person complained against that a complaint of sexual harassment has been made against such a person. And the notification must include basic information of the allegations. We also agreed to the insertion of a provision allowing for electronic notice to be given to the accused. In relation to clause 5.2, we agree further to include penalties for failure of the employer to comply with the timeline of clause 5.1, but that the matter remain in civil nature. So we agree that it is a most egregious breach for the employer not to act in dealing with sexual harassment. We also agree that the penalty for breaches should differ in degree depending on whether the employer is a body corporate. Therefore, we agree that the penalty for a breach of clause 5.1 by corporate bodies should not exceed 3 million, and for the breach by an individual, the penalty should not exceed 1 million. So we are looking at this in context. So what we have to, all right. What we have to determine here, yes, Ms. Grant, go ahead.
Sorry, Chair, I'll wait until you finish.
You go ahead.
I was saying the SG had recommended that all of what is written here be read before we return to the section that was highlighted in red. And I'm just thinking contextually that what came after the sections highlighted in blue would, to my mind, seem to take care of what's here in red, because immediate and appropriate action, the timeline that the committee agreed on for the 2 days would constitute that immediate and appropriate action. But what was being recommended here in relation to the red section was to expand 5.1 to include these words: either receive, so you take the immediate action when you receive the report, or you take the immediate action if you should witness the act. But, and I do recall us saying in a subsequent meeting that wouldn't need to be done. And to my mind, the timeline for 2 days would constitute immediate and appropriate action. Just my thoughts, Chair.
Yes, I agree. I will take Senator Longmore and then Senator Motley.
Thank you, Chair. Thank you, Chair. I'm a little bit concerned in terms of the first aspect of the clause, where it speaks to witness, where the supervisor is compelled and to act if they witness it. I'm not too clear on the provisions for witnessing it, in the sense that sexual harassment can be so subjective that the supervisor may not recognize it as such. In all honesty, they may not recognize that what the individual experienced would have been perceived as sexual harassment. So I don't know if we can put some, I don't know how we can correct for that. And I just wanted to raise that point. The subsequent to that, I share the same concern as you do, Chair. Thank you.
Okay, thank you. Senator Scott Motley.
In respect, firstly, to the comment which has been made by Senator Longmore, her concerns would be covered by the receives a report of sexual harassment. Because as we were thinking about it originally, the sexual harassment being so subjective would be reported by the person. But the witnesses an act of sexual harassment is where the action is so absolutely clear that the average person looking on would be absolutely convinced that it is an act of sexual harassment. And it might be, please do not hold me to account for the example I'm giving, because it might be pinching a woman on her bottom, touching her breast, those kinds of overtures, which nobody could ever be confused about. It would be very clear. I think also—
what did you say? That's
pardon
assault.
me?
That's assault.
Well, you see, there are lots of ways in which we can approach it. And clearly in the criminal law, you might be able to fit it in a box. But having regard to what we are trying to achieve through this legislation, what we're trying to do is to control workplace conduct and to ensure that a worker feels very comfortable, that there's no hostility in the environment. So I think that although different legislations might be used to deal with different things, as we were discussing at length recently, with whether we should go to the criminal court or go to the tribunal. This is one such instance. But I think, but the whole thrust and emphasis of this— I'm sorry, Senator. Please go ahead.
Chair, through you, Chair.
Yes, go ahead.
Yes. What I'm concerned about is—
1 second, Senator Longmore. Were you through, Senator Scott Motley?
No, I wasn't through, but I thought she wanted some clarification based on what I said.
Well, I
Minister.
think maybe you should complete your—
Well, let me finish then.
Yes, and then we come to you, Senator Longmore.
Thank you, Chair.
Right. So the whole point of it is that as the report of sexual harassment would come from the person who is harassed, and that can cover a wide range of things because it's definitely subjective. The reason why we put in a timeline was that we wanted a level of accountability from the employer, and we didn't want to leave it to interpretation what would be immediate action. So we felt, and you were not here, Minister, at the time. It was Senator Gale who was chairing that meeting, and we spent a considerable time on it as to what was even a reasonable notice, a reasonable time period within which, if the employer failed to act, we would hold him accountable. So it was more the immediacy, the action on the part of the employer that we were trying to address in that instance. And
Yes.
I don't think I need to go any further at this stage.
Yes.
Minister.
Okay. Good. Thank you. Senator Longmore.
Okay, Chair. If I will take guidance from Senator Scott Motley that my concern is addressed because what I would hope that does not happen is that an employee can claim that it was sexual harassment on their part, and the employer witnesses the incident, but in themselves does not recognize it as such, and so does not act. So without the complaint of the employee. So what I'm hoping is, so it sounds as if in conjunction with the complaint, the employer witnesses. So if Senator Scott Motley, I will take her legal guidance and legislative knowledge as basis that would be protected from.
Good.
Thank you, Chair.
You. I recognize Ms. Grant and then Mrs. Celie Brown.
I'm sorry, Chair, that hand should have come down.
All right, Mrs. Celie Brown, and then Senator Gill, your hand is up. Yes, I take Mrs. Celie Brown, and then you.
Thank you, Chair. A couple of things, Chair, in relation to this provision. When I look at the report and what you've just read, it looks as if we have a little conflict in how we are going to treat clause 5.1 in relation to the liability of the employer for failure to act. Because we're saying in one paragraph that we agree that the matter would remain civil in nature, which is what I have in my notes. And then further down, we are creating a penalty and differentiating between body corporates and individuals who may run companies. So that I think we'll have to look at and reconcile. In addition to this clause, I think I remember us having extensive discussions on it, and I think we said we were going to adopt the Barbados model, which I can't remember now, and I can't seem to find it amongst my papers. I think you had a specific number of days within the time in which you receive a complaint, in which you must notify the person who is accused of this sexual harassment. And I think we had come to some of the decision as to whether or not we should include what other actions or investigations should take place thereafter. So that's the first point. The other thing is, Chair, when I read clause 5.1 and it speaks about the employer becoming aware, which I think is wide enough to cover what we have here, I don't think we should get so detail into whether or not the person receives a report, because then it will have to come from now, who must that person receive the report from, or witnesses an act of sexual harassment, which created some other concerns legally as to what are we going to determine as somebody witnessing an act of sexual harassment, especially in light of the fact that we are thinking of sanctioning the employer for not acting on any of those actions. So I think, as 5.1 stays, in my view, Chair, becomes aware of is sufficient to handle all of that. And I think we also, in addition to that, just need to go back to the report and determine whether or not we are creating a criminal sanction for 5.2, which I don't have in my notes based on what I've written here. And from what I'm seeing here, I think we're conflating issues, because at one point we're saying the matter must remain civil in nature, and then we're speaking of a penalty later on, Chair. Thank you.
Thank you, Mrs. Celie Brown. Senator Gale.
Good morning and happy birthday, Minister. You look lovely in that color.
Thank you.
And
Dr. Brownberg celebrated hers yesterday.
Yes, and I'm extending belated. I know she's still celebrating. My apologies for joining late. So I had we had lengthy discussions around this particular clause. The concern I have, and if Ms. Grant, you would just go back to what was in red, please.
Mm-hmm.
So receive a report. And you see, becomes aware in my mind, and receiving a report is sufficient. But have a little concern about witness, because you're making a determination as to who exactly is the employer becoming this witness and what level of management would be the one witnessing, and would that person be required to submit a report and go through an investigation? I would just leave it to receiving a report. Yeah, once you receive the report, then the action would be taken from then. The other thing is that I recall us agreeing that it would become a civil matter. And Mrs. Seeley Brown, I don't know if it was the Barbados legislation or the Belize, it was one of the B's, but it made reference to a timeline in which action should take place. I think the insertion of whether it become a body corporate or another type of element, I think that was just part of the discussion. I don't see why we need to separate it.
Yes.
Right? That a body corporate is treated separate from a breach from any other organization or institution. But I certainly did agree that we would have established, based on the deliberation, some level of some timelines.
Yes.
But my concern again, Chair, is just the insertion of the witness being part of the reporting and not just the employer becoming aware or a report is submitted.
Thank you, Senator Gale. Mrs. Seeley Brown, you wish to make a comment now?
Just from the Barbados provision, Ms. Grant, I don't know if you want to look at it. It's section 8. So it says that where a complaint is lodged with the employer, similar to the manner in which we have provided for in our act, the employer shall, in the case where the complaint is made against an employee because they have other persons who may be liable, inform him in writing of the complaint and its details within 2 working days, Chair. And then it goes on to say, commence investigation of the complaint within 14 days of the complaint being lodged and shall complete the investigation without delay. I think it was language of this sort we were saying, Chair, that we would use in this provision, Chair, to make it clear. I just wanted to go back though, Chair, if you would allow me, because I just came up on a provision, even though we have dealt with the whole issue of transitional provisions, Chair.
Yes.
And in relation to the policy statement, and again for Ms. Grant, the Employment Sexual Harassment Prevention Act of Barbados in clause 4, they have a transitional clause, Chair, and it says within 6 months of the commencement of this act, every employer shall ensure that the written policy statement against sexual harassment referred to in subsection 1 is prepared and that the statement is presented to each person who is employed by him. So their transitional period, Chair, is 6 months. Just for the benefit of
yes. Oh, that's good to know. I think a year, we will stick with a year.
Yes, Chair.
Yeah. Now, in relation to this clause, which we need to settle on, the duty of employer, I would say that where the employer receives a report of sexual harassment and not include witness or an act of sexual harassment. Can we, SG?
Then, Chair, sorry, Chair, so you're saying that we, in relation to 5.1,
yes,
we are we then not adopting the position that we had agreed to before, where we were saying that we were going to break the provision down to say that you're giving them a specific time within which the employer must then inform the person who is accused of that act? Are we not going that route again?
Right,
Yes,
but Mrs.
So-
Seeley Brown, look below. It's below. That's the problem. It's below.
Yeah.
It's the paragraph below what's on the screen now. So I think it's a matter
Yes,
of how
yes,
the
up to
report is
days.
ordered. I
Yes,
think it's
yes.
a matter that if we were leaving, so I don't think what's in red can remain as is, because I think what's in red was the fallback position to cover other areas. So I think really what the report should do is start with this what's on the screen now, to say that in 5.1, you are going to have this 2-day timeline that's there to notify.
To notify
And
the person complaining.
Yes,
right.
agreed. Yes.
And that the notification, I think, could also be done electronically. And then I don't think the committee had agreed on the other aspect that's in Barbados. I think it was discussed because remember in Barbados they have another period. You have the 2 days and then another period to commence. There was an issue of whether you say commence investigation. I remember Senator Campbell Rodriguez commenting that perhaps it should be to commence proceedings. I think it was a wider terminology. I don't want to speak for you though, Senator, since you're here, but I know there was a concern.
So far. You're doing well so far.
Okay. So there was a little concern about the other period. And then, so that is not captured in the report, no. Then I think what's in red would have been the fallback in terms of anything that is not that's not covered would have to be done immediately, and appropriate action is to be taken.
But if you are, I'm a little confused. Sorry.
But because if you're going to do a 14-day period to commence investigation for those matters where you're not taking proceedings and so on, then you still need to have a sort of timeline to deal with those matters, because everything may not result in you taking proceedings, for instance.
Fine. So why then can't we use language similar to Barbados? You commence investigation into the complaint, because you would have received this complaint, then you would have informed the person against whom the complaint is made that this complaint was made. The next obvious step is investigation of the complaint.
Right, but there was a concern about using the term investigation, so that's what I'm pointing out.
I'm not understanding.
Madam Chair, I was not the word investigation. I don't remember specifically who brought up the issue of the use of the word investigation, so I'm trying to paraphrase that bit. The rest of what Ms. Aldred said is definitely some of the things that I raised. When I don't remember who it was that I don't remember if it's Minister Johnson Smith or who it was who spoke specifically that investigation is very specific. Versus, informing the person who is the accused. Yes. The word investigation would not cover that. Which is why we needed a broader term.
Yes. All right, I'm gonna ask Ms. Grant. Ms. Grant, could you?
Yes.
Yes.
So SG, if I understand what you're saying, that the red would not be needed because what's here would take care of what's in the red, right?
No, that's not what I'm saying. That's not what I'm saying. So Barbados has a system where we have adopted one part of it so far, which is on the screen,
2 days.
which is the 2 days to notify someone. The issue is what happens after. Now, if we were going with the Barbados model, then we would have had another 2 weeks within which investigations are to commence. But there was some concern about speaking about investigations.
Right.
So I'm saying if we're not going that model, then you would need to do something else. So if it is that you want 2 weeks, the issue is what do you want to do next after that notification of 2 days?
Okay. But
perhaps if we're clearer on that, then we would know what next to put in the legislation. I was also saying, depending on what is agreed for the next step, you may still need a backup. You may still need, because if it's too narrow, then you may still need what I would say is a catch-all to say any other appropriate action should be dealt with immediately.
Okay. But this and I understand what you're saying, and I agree with what you're saying. But this thing here, what's here in the red is really is to say, do we expand 5.1 clause 5.1 to include, instead of becomes aware, to say receives a report, or
Okay. No,
right?
so remember what I was saying is this: you wouldn't start with this. So there would be some reformulation in it and some rephrasing. So you would start with what's on the next screen.
Yes.
Okay.
That's where you would start.
Yes.
So you would start with what's on the next screen and say that you are amending 5.1 to first provide a timeline of 2 days for notification. We then need to know what the committee is saying happens next. If you think that it could be okay to say another 2 weeks within which investigations should commence, then we could go that route.
Or?
Well, I'm not clear on how else to frame it, because I remember being asked to look at language, but I haven't been able to come up with anything else. Because generally, when you look at things like this, the next step is really for an investigation to be commenced, because normally you don't take any other action until you start your investigation. Now, it is true though that even while you're doing an investigation, for instance, you could institute or indicate that counseling should start at that time. So there is other action that can actually happen while you're doing investigation. So for instance, you may have a victim who is so traumatized that you realize that counseling needs to begin immediately. And that is a step that could happen while you're doing investigation. But I think with Barbados, they weren't treating with any of that. They were just giving a timeline for notification of the complaint to the alleged harasser and the commencement of
investigation.
The investigation. That's all they were basically dealing with. But I remember the discussion that committee members wanted more addressed here.
So, well, would we want to go with the commence investigations in 14 days?
Chair.
Yes. I'm sorry, Mr. Seeley Brown, you wanted to make a comment? I see your hand up.
Sorry, Chair, I'll wait until Senator Gale is.
Okay.
Chair.
Yes.
So you receive a report of an allegation for sexual harassment. The two most important action would be, one, to notify the alleged perpetrator, which is what is contained in this. And after that, the next most appropriate and immediate action is to commence an investigation. Those are two clear functions that would be understood to be immediate and appropriate. Everything else will fall in place, you know. But it's not everything that we have to include in the legislation, because some things may not follow. But the two most important and immediate action is to say to the person who is the alleged perpetrator, we hear say you do this. And then to commence the investigation. Everything else follows from that. And I believe if we're going to include any structured action, those two ought to be. They are, in my mind, the two most critical. And everything else will fall in place. That would be my suggestion. And we can agree to utilize the 14 days to commence such investigation.
Thank you, Senator Gale. Mrs. Celia Brown, and then Senator Scott Motley.
Thank you, Chair. And just to add to what Senator Gale is saying, when I look at I think the concern that the persons who made presentations had maybe could have been the fact that you speak to the employer becoming aware and not a specific person making this complaint. Now, when I look at the Barbados legislation, it doesn't speak generally to the employee becoming aware. It places a duty on an employee who alleges that he or she has been sexually harassed to make a complaint to the employer. So that then follows the fact that when the employer receives that complaint, he has 2 days in which he must notify the person who is accused, and then 14 days in which he or she must commence investigations. So it is triggered by a complaint being made by the employee. So maybe we need to be clearer so that we don't have to insert provisions that are vague, like receives a report of sexual harassment or witnesses act of, even if you don't want to limit it to the employee making the complaint, but put the duty on somebody to make a complaint to the tribunal, and to the employer, and then trigger the actions of the employer to the 2 days in which he must notify the person who is accused, and then if you so agree, the days upon which he or she must commence investigation.
All right, so are you suggesting a rewording here?
Well, if it's agreed to by the committee chair, just yes, based on what I'm seeing in other jurisdictions.
Okay, can you let us hear what you're proposing?
That you, rather than speak of the employee taking action when he becomes aware, have a procedure or mechanism for somebody to make a complaint. Whether it's the employee or somebody acting on behalf of the employee in Barbados, this is the employee. So you have them lodge that complaint with the employer, and then when the employer receives that complaint, he then acts within the periods that we are proposing, which would be the 2 days to notify the person complaint, and then the committee must decide whether or not you want to add the part that speaks to the conduct of the investigation, which to me, Chair, is a natural course of things. Once you receive a complaint, even though you're doing other things which you may not put into the legislation, the next step is to investigate that complaint. I have no difficulty, Chair, with speaking of having a timeline for commencing an investigation of a complaint, and once that is approved by the committee.
And we could work with the 14 days as well.
Well, yeah, I have no difficulty with it, Chair, but as I said, it's for the committee to decide how you will proceed.
I will hear Senator Scott Motley's comments, and then we need to make a decision.
I was going to remind the committee, Minister, that the reason why we had the debate around it and tried to address it in the way that we did was because of concerns with what was meant by being made aware. Now that I've heard a proposal by Mrs. Celia Brown in the way that it is framed in the Barbados legislation, I think all our concerns could be addressed if we made the onus be on the employee rather than the employer. In terms of the 14 days timeline, it would be interesting if the minutes were revisited, because we had such a long discussion on it. And it is also going to come up in clause 6, where we also deliberated as to the 14 days. I can't recall the discussion, Chairman, Minister, the details of the discussion, but there was something which a member said which persuaded us not to go with the 14 days. I think it would be useful to have the timelines of the 2 days and the 14 days, because then it gives you a context within which the employer is forced to operate. Yes. But my own concern now is, why did we not embrace it totally? What was the discussion? What in the discussion made us hesitate? And perhaps at a convenient time, Minister, Ms. McCarthy can just refresh our memories. I conclude by saying, though, however, that it would be, if we accepted the Barbados proposal, it might meet our concerns. Thank you, Chair.
Thank you, Senator Scott Motley. Mrs. McCarthy?
Yes, Minister.
Yes, can you recall?
Well, I have on the 14th of April, the committee contemplated the 14 days for the investigations to commence. I don't recall a decision being made or the reasons why. I know it was a back and forth between the 2 days and the 14 days, but there was nothing specific as to, I can't recall from now, and I would have to double check while the meeting is going on to see what the issue was.
Okay.
In which case, Minister, we should just proceed. It seems now as though we all accept the 2 days and the 14 days. And I think that we should proceed with that if there's no dissenting voice.
Yes, I think we should proceed, and I'm not hearing anyone objecting to us proceeding.
Chair.
Celia Brown, you wanted to say something here?
Yeah, just to clarify, so we are then going to rephrase to have the employer make that report to the employee make that report to the employer, rather than speaking of becoming aware. We have agreed to that and adopting what we have in similar provisions to what exists in Barbados.
Barbados, yes.
Okay.
For that.
Thank you, Chair.
Okay, thank you. All right. Miss Grant?
But Chair, I'm sorry, do we keep the penalty section that Mrs. Celia Brown had mentioned about the body corporate and individual? Would we keep that, given that we had said that it's supposed to be dealt with, it's supposed to be civil in nature? Would we still keep this part on the screen?
Thank you, Chair. So thank you, Ms. Grant. Yes, Chair. That's an issue that we need to determine, because we're saying two different things in two different paragraphs. In relation to, it says in relation to 5.2, we refer to include penalties for failure of the employer to comply, but that the matter remains civil in nature. So I'm thinking of maybe punitive damages and that sort of thing you're thinking about in respect of the tribunal. But then you go down further, the report goes down further to speak of a fine of 3 million and a penalty not exceeding 1 million for Chair. So that decision, Chair, needs to be taken as to whether we're going to keep it civil in nature or you're going to impose a criminal duty on the employer who fails to take action in relation to clause 5.1.
All right, I will recognize Senator Scott Motley here, Mrs. Celia Brown, and then we can make a decision on that. Go ahead, Senator. Senator Scott Motley?
I'm sorry, Chair. I was momentarily distracted. Could you just repeat that?
Yes, you had your hand up. You wanted to make
no, not at all, Chair. It's just forgetting. I will take it down immediately.
All right, Senator Gale, thank you.
Chair.
Yes.
Chair, I remember when I had indicated why it should have been a civil matter, because this was the one where if it becomes a criminal matter, the employee would not benefit. And it's the employee who would have been disadvantaged by the employer who would not have taken the appropriate and immediate action. And I am of the profound view that if it rests in the hands of the tribunal to make a determination, then the tribunal can so make an award that it would include damages to the employee who would have suffered. And that is why I had suggested that it ought to remain a civil matter.
Thank you, Senator. Can we all agree that it remains a civil matter?
Agreed, Minister.
We agree.
I agree.
Okay, good, thank you. So this would change. Ms. Grant, can you indicate here?
So we
We take out?
You take out the penalty, the penalty, Minister, and yeah, the damages would only be, it wouldn't be a penalty, it wouldn't be a duty imposed then. Right, so whatever is imposed would be in the realm of, I guess this is something that we're saying that the tribunal would deal with, so the tribunal could, I don't know.
So we need a reword, we need to reword this. We delete, therefore we agree that the penalty for breach, clause 5.1 by corporate, but should not exceed it. We would delete that, and what would we replace it with?
Chair, couldn't we just delete that entire paragraph? Because we already speaking in the paragraph above of the matter remaining civil in nature. So can't we just delete from we in the next paragraph?
That's
Amelia?
right.
Yes.
Yes, I think so. Everyone agrees? Okay, I hear no dissenting voice. Thank you. Okay, so we move on to clause 6. Duty of person in charge of an institution to take action to deal with sexual harassment. Clause 6 addresses the duty of person in charge of an institution to take action to deal with sexual harassment. Now, in respect of immediate and appropriate, at clause 6.1, your committee accepts or does not accept the proposal and agrees to establish a specific timeline, that is a period of no later than 14 days to commence investigation on matter. So we have agreed on that.
Chair.
Yes?
Yeah, I think we will just have to redraft those provisions, Chair, similar to what we did in 5.1.
Yes.
Because it would flow from there. So okay. The person must make the complaint, and then the person who is in charge must have a duty to act within that particular time. So that provision would read similar to what we have decided to similar to the amendments that we're going to be making to clause 5.1.
Okay, fine. All right, so we're redrafting that. All right, your committee notes the proposal to add a clause that allows for recourse where the institution has taken immediate and appropriate action under subclause 1 and proceed and process the complaint. But the complainant is aggrieved by the outcome, so that the complainant is allowed to make a submission to the tribunal indicating why he or she is aggrieved and present evidence to substantiate the claim. Your committee, not able to read that, Ms. Grant, your committee accepts the recommendations and agrees to expand the provisions of clause 25.1 by inserting a subparagraph D to permit direct application to the tribunal for a hearing where the complainant is dissatisfied with the results of the internal mechanisms and feels that his or her complaint has not been addressed adequately. We agreed on that, and so we can move on. Your committee notes the observation that there is no immediate requirement for the employer or person in charge of an institution to ensure that accurate and complete records are maintained and retained in keeping with legal requirements. We note the proposal to add a subclause that reads, all involved in dealing with alleged sexual harassment claims should be aware that any notes that are made or documents that are created could be requested by the tribunal as part further investigation. That doesn't read right.
That should be as part of.
As part of further investigation, and individuals could be called to give evidence. All efforts should be made to ensure that written records are clear, accurate, and appropriate. Your committee accepts the recommendations for the keeping of records and agrees that it should be a standalone clause which creates a duty for the keeping of records, the particulars of the records, and how long records will be kept. The duty of confidentiality, among other things, We also agreed to add provisions that address breaches in relation to the keeping of records, ensuring confidentiality, etc. That's agreed. So part 2, forms of sexual harassment and related prohibited conduct. Clause 7, sexual harassment by an employer, supervisor, or co-worker. Clause 7 covers sexual harassment by an employer, supervisor, or co-worker. Your committee notes the proposal to expand the scope of part 3 specifically to include in clause 7, third parties, such as non-contracted persons, customers, vendors, clients, and business partners who interact with institutions and businesses as categories of persons that may be vulnerable to sexual harassment. Next, we agreed there. Your committee notes the proposals to A, expand the scope of part 3 to include harassment between an employee and a customer, client, visitor, or any other person who accesses services and the immediate duty of the employer to address same. B, explicitly state how to treat sexual harassment by third parties, such as non-contracted persons, vendors, clients, and business partners who interact with institutions and businesses. C, expand the scope of the bill to include not only employers, supervisors, and co-workers as perpetrators of sexual harassment, but also sexual harassment by employers, relatives, and even friends in cases involving household workers.
Minister?
Yes, go ahead.
Sorry, can we go back to that slide that you're coming from?
All right, Ms. John.
This is just a grammatical thing for ease of. Part C, can we change employers' relatives to relatives of employers?
Harassment.
Easier to read, easier to.
By relatives of employers,
Yes.
I don't see a difficulty with that. We can change that.
Thank you.
Right. Okay, Ms. Grant, go ahead. Your committee accepts the recommendations and agrees that sexual harassment by third parties should be addressed. We also note the observation with respect to contracts for service and the proposal that a condition of such contracts must be that contractors must not sexually harass any worker or person engaging business on the company's premises. Your committee accepts the recommendations and agrees that sexual harassment by third parties is addressed by way of insertion at clause 7, and clause 3.1 imposes a duty on the employer. Agreed?
Agreed.
Next. Ms. Grant?
I'm sorry, Chair. I'm just looking back at what you just read, and I'm thinking that the correct thing that we agree to the insertion in 7, but it says that third parties is addressed by way of insertion. So, because it is addressed to my mind, it says to me that it's already there when that it's not necessarily the case. So it possibly should be a thing that accepts the recommendations and agrees that sexual harassment by third parties will be addressed by way of an insertion at clause 7. I'm wondering if that is how it is, if it's supposed to read that way.
If it should be addressed?
Madam Chair?
Yes, go ahead.
What I understood it to mean and what is in my notes is that we were to have a clause drafted and inserted there. Which would mean it's correct, but I'm not sure that we ever got the clause. But I could be wrong. To be inserted, because I don't have anything here which shows me what the clause will be.
Yes, Chair, and that's fine. The fact that we don't know what the clause will be, that's okay. That would be left to the drafters, because we had looked in, I think it's the Australian legislation. We had looked to that for guidance and another piece of legislation. So that is not it. But I'm saying, Chair, that I think the correct wording would be that it is future. The correct wording should be futuristic in nature because it's not currently provided for.
All right, so it should read.
Your committee accepts the recommendations and agrees that sexual harassment by third parties should be addressed by way of an insertion at clause 7. Clause 1 imposes a duty on the employer. Give me a moment.
Yeah.
Madam Chair, while she checks, my notes say that we said the clause was supposed to be drafted, the insertion was supposed to be drafted, and that the matter of who the duty is on is already addressed in 3.1. So I'm not sure.
Okay, right. Yes, Senator Campbell Rodriguez, that's true. So the only thing that, sexual harassment by third parties should be addressed by way of an insertion at clause 7, and something that recognizes that the duty already exists on the employer in clause 1, and so it just needs to, so that I'm still working through the drafting in my mind, Chair, but clause 1 already imposes the duty, but third parties are not specifically addressed. So it would just be to insert that a clause in 7, which would recognize sexual harassment by third parties.
Chair.
I see Mrs. Celia Brown and then Senator Vince. Go ahead.
Because I'm a little confused, Chair. First of all, in relation to the proposals, we have to note that some of the categories of persons who are stated here are already covered under the legislation as workers. For instance, it speaks to domestic worker in a definition of worker. So but when you speak of employers, relatives, and friends, remember, Chair, we are drafting the bill in relation to a specific scheme, and it deals with sexual harassment in the workplace, institutions, and whatever. And we have our scheme is clear as to who shall not sexually harass. Is it because I thought, Chair, when we were speaking of it and decided to adopt the Australian model, we were speaking of sexual harassment in the terms of providing goods and services or facilities to a person at a workplace. So I didn't think in my mind that I would have to come up with this definition of a third party, but basically adopt what is in clause 28G of the Australian model to suit, or what I'm going to read it, to suit our circumstances. And it speaks to goods, services, and facilities. And it says, it is unlawful for a person to sexually harass another person in the course of providing or offering to provide goods, services, or facilities to that other person. And subclause 2 speaks, it is unlawful for a person to sexually harass another person in the course of seeking or receiving goods, services, or facilities from that other person. So that is one way in which it could have been drafted. When I looked at the Barbados draft, Chair, that tries to incorporate this third party concept, it speaks to a client. And it says a client means any person who conducts business with an employer. So it still links it to that workplace scenario. So when I'm seeing all of these scenarios, Chair, and this whole thing about third parties, in my mind as a draft, I'm not clear as to what is the mischief we want to capture. Are we expanding it to somebody who walks into your business to conduct a service and they may sexually harass one of your employees? Or your employee may sexually harass somebody who's coming there to do business, which is what my notes have? Or are we extending it to these? I don't know how we can, in the scheme of the bill, expand it outside of the workplace to include an employer's relatives and friends. I'm not clear as to what the mischief is and what is the decision as respect to how we're going to move forward in redrafting the provision, Chair.
Chair, may I please?
Who is that?
Oh, that's Miss Grant, Chair. But if there's
Miss Grant, yes. Could you put her?
Sorry, I was Mrs. Celia Brown in relation to the Australian legislation. That was my understanding too. That third parties would be, we would resemble whatever provision is drafted would resemble that in the Australian legislation. That was my understanding as well. The thing about employers, relatives, and friends, though, that I wanted to make clear here, it was a submission that was made by household workers,
yes,
that group. And they were looking at it in the context that when a domestic worker is doing her workplace being the home of the employer, that the third party to them would be relatives of their employers who might, in certain situations, sexually harass them. So they were looking at third parties from that standpoint. So that is why that was placed there. So if their friends, when their friends come to the home, their relatives come to the home, those are third parties to them, and there are instances where persons have been subjected to sexual harassment in those instances. But when we did discuss it, I did come away with the impression that we were going to look at third parties in relation to those who provide goods and services, and even adopting a bit of what Barbados has about a client who comes in and who sexually harasses workers.
Thank you, Ms. Grant. I'm going to recognize Senator Fraser Binns and then Mrs. Salmon. Mrs. Celia Brown, you had completed your comments, or you?
I'll hold on until other comments are made, Chair.
All right, thank you. Senator Fraser Binns.
Morning, Chair. Good morning, colleagues. Ms. Grant, could you scroll up a minute for me? I just want to read something and seek some clarification. Thanks. Just down a little. To the red writing that speaks to third party. Essentially, while Mrs. Grant finds it, well, yes, here it is. It says that we also know the observation with respect to contracts for service and the proposal that a condition of such contracts must be that contractors must not sexually harass any worker or person engaged in business on the company's premises. And I wondered whether we wanted to say, company's premises, because throughout the discussion, we have agreed that the workplace is not a physical location. And if we are saying, or if we're using the word company premises, whether or not we will be limiting ourselves to what happens on the physical premises, or do you want to say workers or person engaged in business with the company? I wonder whether that would be a better wording rather than company's premises. I'm not sure who's gonna. Yes, Mrs. Celia Brown.
Well, it's kind of not a point that's linked to your point, Senator Fraser Binns, because I think if we include the provisions with respect to goods and services, it will cover that what is in red, because under the definition of worker, look at paragraph C of a definition of worker, which would include somebody who is a contractor. So that is already covered, and then the whole thing about contractor not sexually harassing any worker, that will then be somebody who is offering goods and services to that person in the course of that person's employment. If we adopt what is in the Australian model, or even if that person employed from that business who has that contract is sexually harassing, because it speaks of it too, what I just read there. So I don't think we need to I don't think that we need to place it like that in the report, and also because some of the things that are mentioned here are already covered under the definition of worker, Chair. So I think the decision will just have to be how and where we insert, whether or not we're going to go with the whole issue of sexual harassment in the provision of goods, services. to further cover what is stated in the report.
Okay, thank you, Mrs. Celia Brown. Mrs. Simon?
Sorry. Yes, Chair. Was just wanting to make a comment about the concern with the family members, the relatives of the household worker.
Yes.
It was just to say that I believe that they would be covered under clause 3 because the employer, in that case, in the case of the household worker, has a duty to make sure that that they're not harassed in the course of their environment. So that to me would take care of their relatives. The household worker should be able to make a complaint that they're being harassed by that person, and the employer should take care of that.
Okay, thank you.
Agreed, Chair.
Thank you, Mrs. Simon. Thank you.
Agreed, Chair.
Yes, okay, good, good. All right, so what's the decision here now in relation to where we note the observation with respect to contracts for services and the proposal, and what Senator Fraser-Binns had proposed the change here? How do we treat with this paragraph?
Madam Chair?
Yes?
I don't have the wording, but I want to just submit that Senator Fraser-Binns' comments are quite valid in terms of the use of the term company's premises.
Okay, thank you. Ms. Grant or Mrs. McCarthy?
Yeah, sorry, Chair. I just want to say here, this bit in red, it was a proposal that was made by an entity. I can't recall which of the entities at this moment. So it was a proposal that was made. So how it is stated there is exactly as it was proposed. So then to me, what Senator Fraser-Binns said would come then in your committee accepts the recommendation and agrees that or your committee does not accept the recommendation and include that part about what she said about companies' premises. But what is there in red was the proposal, an actual proposal.
Yes, but so what I'm saying is if we're accepting it, we just need to now ensure that we have captured the wording, the appropriate wording.
All right, I'll ask Mrs. McCarthy, Chair. I was.
Yes.
I would just ask that. Well, I would ask that the proposal for that, is it for that section or the entire passage about the third parties? Just want to be specific about what part is it that we're changing or we're accepting.
Madam Chair?
Yes, go ahead.
May I please respond?
Yes, go ahead, Senator.
What is in red? I think it's two different issues from that paragraph. What is in red? The last section which says on the company's premises. Senator Fraser-Binns is saying we should reword company's premises to take into consideration the fact that we're saying that space could be virtual. It doesn't have to be a physical building. So that's one. And then further down, Ms. Grant was saying that the last sentence, the phrasing of the sentence did not fully capture. And she was going to think about how to rephrase. I think, I'm not sure if I missed it where she did come back with her suggestion, but that's my understanding of it. But I think if we put in the word "and" after the word "of" in the last sentence, the second to last line, it probably could solve a bit of the question there, because I understood it as intended, but Ms. Grant did not. And as such, once someone doesn't interpret it properly, we have to just make. So I think if we say it's addressed by way of an insertion at clause 7, and note that clause 3.1 imposes a duty on the employer, that could make the statement a little clearer.
Chair.
Yes, go ahead, Senator.
Chair, you see this thing where we have on the company's premises?
Yeah.
It really limits the possible interaction. Because I have some members that I represent that have to interface with customers who send them text messages or emails. And so if we limit it to on the company's premises solely, why not just have a full stop on persons engaged in business?
Any worker or person engaged in business.
Right.
All right.
Not on the company's.
Yes, noted. I know Mrs. McCarthy wanted some clarification here.
So, excuse me, Chair. So, as Ms. Grant had said earlier, what we have, when the report says your committee notes the proposal to X, Y, and Z, it is from the entities that had sent the report and those that we read into from the matrix. So I'm understanding the part about changing what it says about the company's premises.
Right,
However,
so
I would
end that business.
Sorry, Madam Chair, may I ask a question, please? My apologies, I'm a late arrival. And happy birthday to you.
Go ahead.
Thank you. Sorry, just to interject on this point, and sorry, Ms. McCarthy, for interrupting you. But I had just wanted to be clear that this was in fact an agreed proposal, because I find it a little odd.
Clarification, anything is in red was not agreed on.
Okay, right. So my question is, if it is, if legally, if our law says that a person must not be sexually harassed, that workers must not be sexually harassed, and sets out those circumstances, I'm not understanding, and if this applies whether you are employed under a contract of service or a contract for service, or if you are appointed, why are we asking contractors to put this clause in their contracts of employment? Is it that they will have more protection against the law than persons who are employed and are employed in a way that doesn't have that as a term of their contract? Why should an employee who has greater security of tenure not have it in their contract, but someone on contract for service should have it? I must have missed that part of the discussion, so I apologize to colleague members of the committee if this has been gone through already. But if the law prohibits this action, why are we stating that in particular contracts this should be included? So I'm beyond the question about, certainly if the committee is requiring this to be in, then I agree with the point that's being made about not referring to companies' premises based on our previous discussions. Clearly, we said the work environment needs to include the virtual space and other places where the business of work, or rather where the work environment manifests itself. So, but the fundamental point, and the comment is there in the draft, asking whether this whole thing is being accepted as well. That point misses me, and the justification for asking for it in one particular type of contract, I think raises difficulties in terms of all other contracts and all other types of engagement. So I'm not sure I am supportive of this view.
So you're saying this is not necessary?
I am saying it is not necessary because the law is supposed to prevent harassment of any worker, regardless of the type of contract you have. So inserting it, I know that some people don't understand the law of interpretation, meaning that the group that suggested it may sort of not put forward the position, understanding that putting something in one place and not in another may lead to another type of interpretation or another manifestation of the type of protection. Okay. So I think that the committee might want to view it in a broader context.
Okay.
In light of the definition for worker.
Yes.
You're correct.
Yes. Noted. Ms. Grant, I think you wanted to make a comment here. Thank you. Thank you, Minister Johnson Smith.
I just, well, it was in the earlier stages of Minister Johnson Smith's contribution, but I think she came around to it in the ending. I was just pointing out that it wasn't something that the committee had agreed, Minister. It really was a proposition by another entity. And so then it is on us, as you said, come at the closer to the end, coming to the justification that we do not accept this proposition because the law already provides for so. So I just want to make that clear.
That's right. So this is all right. So this is it's not necessary, and so we do not accept this proposal, right? Okay, and then so we move on now. Your committee accepts the recommendations and agrees that sexual harassment by third parties is addressed by way of insertion at clause 7 and clause 3.1 imposes. And you had suggested a rewording of that, Senator Campbell Rodriguez.
I'm sorry, Madam Chair. Can you repeat that? I didn't hear.
You had suggested a rewording of your committee accepts the recommendations and agrees that sexual harassment.
If we're not accepting the recommendation, I think it becomes null and void.
Yeah. Okay.
Because based on what Minister Johnson Smith has said, it really does make sense to have this clause.
Yeah.
It's not relevant, so I don't think we have to worry about the bit in blue.
Ms. Grant, could you?
Minister, I'm confused. I'm confused because the thing about I'm confused. The thing about third parties that was mentioned, I'm not sure what Senator Campbell Rodriguez just mentioned. Yeah, I'm not sure.
Let me just clarify. What's in red was a recommendation that was not agreed on, and we have decided that it is not relevant. But in relation to third parties, your committee accepts the recommendation and agrees that sexual harassment by third parties is addressed by way of insertion at clause 7 and clause 3.1. It imposes a duty on the employer. That's a different discussion, isn't it? Ms. Grant?
Yes, Minister. Okay, I get what you're, okay, all right.
Right, that's a different discussion, Senator Campbell Rodriguez.
Correct.
All right, so
Minister, if I may.
Yes, go ahead.
Just a clarification, are we agreeing then, are we saying that the issue relative to third parties, including contractors, that is sufficiently covered under 3.1, and as such, we do not need to insert a provision under clause 7? Is that what we're saying?
I think, Minister, if I might, if I understood again, and apologies because I came in late. I came in on the specific point of discussion regarding the inclusion of a clause in contracts for services, and that proposal continued to speak about persons engaged in business on the company's premises. What my intervention was, and which appears to have some agreement, is that the work, given the definition of workers and given the structure of the law, this particular proposal, which is that contractors should include in their contracts for service this duty not to sexually harass. If that fundamental part is agreed to be unnecessary in light of the fact that the Act prohibits sexual harassment, and then the issue on which we were all agreed, which is that the work environment is intended to include the virtual and include beyond the company's physical business location, anywhere that work manifests itself, that part would fall away because we would be agreeing that this particular type of change wasn't necessary. That is a duty for all contractors to include in the contract for services a duty not to harass. because that's already going to be provided for in the contract. But that is not to comment on the broader issue regarding third parties, which the committee had separately agreed needed to have a proper formulation included. So it's just the single issue and not the broader issue of third parties.
That's correct. That's correct.
Thanks for that clarification, Minister.
Okay, so Mrs. McCarthy wanted to make a comment here.
I just wanted, I was listening to Senator Scott Johnson Smith, sorry. So I'm wondering, Minister, if what we had said earlier about at the beginning of clause 7 would address what we're talking about now in terms of third parties, and therefore the section that is still in red, we would say we do not accept the recommendation in the story for that.
That is what we are saying. We will
So,
not accept.
Okay, so therefore the part about the insertion, I'm just wondering, because it was attached to that part about contracts up for service.
Right.
If I'm getting it right.
In red.
Sorry, Madam Chair, might I ask a question? And this may really be for the technical team. Whether it is that we would have needed in 7.1 to go beyond an employer or a supervisor or a supervisor or a contractor shall not sexually harass a worker, given that the definition of a worker includes a person engaged under contract for services, etc. It includes an employee, it includes a contractor, but here we only use the word employer or supervisor. Is that a solution to or at least a partial solution to the issue of ensuring a more express duty in respect of contractors?
Who would want to take this, Mrs. Celia Brown or Mrs. Masado? Mrs. Celia Brown?
Chair, I thought we had agreed that we were inserting provisions, but it will definitely be in clause 7.1 to expand it to deal with persons who are either providing goods, services, or facilities to a worker who is harassed, or the other way around, where that person who is providing goods, services, or facilities is harassed by a worker. So I'm saying yes, we would have to include additional provisions to incorporate these third parties that we refer to.
Okay, but in addition to third parties, this concept of the contractor dealt with as a different person than an employer, because they are treated differently in the definition of worker, sorry. They're particularly identified in the definition of worker, that is the employee and the contractee. But in 7.1, so yes, the third party, I get that, but in 7.1, we only refer to the employer or the supervisor, but there's no reference to the contractor. I'm just asking about closing that circle in your additional language so that it's not, because you're speaking to the third parties, which are a little different, no?
I'm not sure. Is it that now we're saying that we want to include a particular provision to deal with contractors?
No, I'm not asking about a particular provision, but I'm asking what is the solution then? If it is that we have expressly put a duty in 7.1 on employers and supervisors,
and we should include contractor there.
That's my question, because in the worker definition, we do have persons engaged under a contract for services or a subcontractor listed separate for an employee, from an employee. So I'm just asking where that person would be mentioned, where a contractor, to ensure that the position of saying that you don't need a contract for service, because the law makes it quite clear that contracts for services are covered. But noting that 7.1 speaks to employers and supervisors.
Only, and does not refer to contractors.
Right. So I'm just asking whether that solution, this is different from somebody who, you know, is buying something from you. This is somebody who's working for you who is engaged under a contract for services. I just trying to ensure that that gap is not left open.
A contractor or a subcontractor. What would you say there, Mrs. Celia Brown?
Chair, I'm not sure right now. Chair, I'm thinking about it still. Chair, I'm not sure right now.
Chair, may I offer a suggestion?
Yes, Mrs. Masado.
In terms of the wording of the report, I'm suggesting we say your committee does not accept the recommendations, but agrees that sexual harassment by third parties should be addressed by way of amendment to clause 7 in order to expand protection to persons providing and persons receiving goods, services, and facilities, full stop. So we're not going to specify now how exactly the drafter will amend it, but at least to give the principle that we want to include these categories of persons that Mrs. Celia Brown has indicated to us from the Australian legislation.
Okay, thank you, Senator. Minister Johnson-Smith.
I think that's a great suggestion, but my initial query still lies.
Doesn't address what you raised.
Right. The point being that of persons.
Yes. I think that we could at least accept this wording and get that out of the way, and then go back to the issue you raised. Do I have an agreement there?
But Minister, I was just checking whether inclusion in that would be persons engaged under contract for services as well as persons providing services or whatever, because that was really more, the third parties were really people coming to buy something from you or to take a service from you, as opposed to someone who is engaged in something that's similar to employment, but is not, because it's a different type of contract. That's all that I'm trying to ensure. I think it would be treated in the same comment.
Yeah, I think we should go back and look at 7 and consider what you have said. And Mrs. Celia Brown said she'd just require a little more time to think about it. Right?
Minister, if I may,
yes.
I'm agreed with Minister Johnson-Smith, because again, if we look at the definition of worker, the definition of worker really includes a person engaged under a contract for services. And to that extent, we would not need to make a specific provision for that again. I do recall in the discussion that we have been having that the third party that we spoke about had to do with a person who comes, for example, to the supermarket and harasses the cashier or a guest at a hotel. I think those are the persons that we were talking about, right, Senator?
Yes.
When we're talking about third party. And I think that is a concern that she has, which I'm agreed with.
Can I just clarify something from Minister Johnson-Smith? So the definition of the worker to which Senator Fraser been spoke about in C, a person engaged under a contract for service or a subcontractor of that person. So we're seeking to protect those. But sorry, I'm getting a feedback. But Minister Johnson-Smith, the person who you outsource some service to, let's say you bring in an outsourced service of some contractor, some business. Are we saying that they would be considered as a third party? You don't directly employ them. They're not on your payroll. I'm trying to break it down. But you would have outsourced the services to them and they come in. Are we trying to protect the internal employees from the exposure and risk of that outsourced service sexually harassing the employees?
Thank you.
Was that the distinction that you were trying to make?
I think you have gone down a slightly different path, Senator. The fact is, my point was really that the way in which people are engaged, given the definition of worker, and I spoke to that as well. I said that in the definition of worker, we have named the employee, whether in private or public, we have named the person engaged on the contract for services or subcontractor. They are distinguished. And yet in 7.1, the duty is expressly placed only in respect of an employer or supervisor. So my question was whether the duty should not clearly be expressed there in respect of a contractor as well, someone who engages someone under a contract for services, because we know that many persons may appear to be quote unquote employed as defined otherwise, and as under the common law and under the relevant legislation with which you are far more familiar than I. But we would want to ensure that this concern, which was clearly had by a contributor to the committee, that persons engaged under contracts for services would similarly be protected. My view is that insisting in the law that all contractors put that in their contracts would not be necessary, because what we should be doing is ensuring that this law ensures that all contractors or all persons who are engaged under contract are protected by a duty of that employer or contractor not to sexually harass, rather than, because how are we going to monitor and police everybody's contract where that exists?
You can't.
Exactly. So you put it in the law so that the obligation exists across the board. In respect of your scenario regarding outsourcing and persons brought in to perform broader contractual duties, those are to be covered by this act as well, under the definition of law of worker. So a person engaged under C, contracts or services or subcontractors, etc. Their employees would be covered, and they'd be covered also by whoever retains them, not necessarily the original duty, by insisting that they're contracting, that by the contracting company would have an additional clause, but because this duty exists in the law for all workers not to be harassed.
Agreed, and that's where I was seeking the clarity.
Yes, so that's—
And also that they would be seen as a third party.
Well, the third party definition, as Senator Fraser-Binns was just reminding us, and the recollection of which I share, is that the discussion about third parties was really about people who engage with an entity. So if I'm coming to shop in your store, if I'm coming to your supermarket, if I'm coming to procure your construction services, whatever, that I am, as a quote unquote third party to your normal employment system, still, if I'm in your bank, I still require some protection from being harassed therein by your employees because of the environment within which I am. So that—
or vice versa.
Right. So that's exactly. So I think that was the discussion. We were trying to ensure that neither aspect is lost in the adjustment. And so Mrs. Mesado's proposal about broader language, I agree with that approach. I support it, but I would like to ensure that it includes both aspects of contractual engagement for work, that is, as opposed to an employer or employee, supervisor, supervisee, but a contractor and contractee or subcontractee, as well as the third parties as they were previously discussed by the committee, that they should all be included. That was my understanding that the committee wished to achieve.
Yes, thank you, Minister Johnson-Smith. I see Ms. McCarthy hand up and also Ms. Grant. You want to address this?
I'm sorry, Minister. I was listening. I should have taken it though.
Okay, Ms. Grant, thank you.
Yes, Minister. I was just listening to what Minister Johnson-Smith said about the contractor and the contractee. And I I just went to look at the definition of employee, and I'm wondering, Minister Johnson Smith, if that specific designation for the contractor, as opposed to the contractor juxtaposed with employer, if that would not need to be made, given that employer is defined in the bill as employer means a person who engages in any form, a worker, and if they're already
yes, agreed.
So you wouldn't need that. So the duty would still devolve on the contractor, i.e. the employer, to ensure that this would be done.
If you feel that the clarity is not necessary in 7.1 because of the breadth of the definition of employer, I would be happy to be guided. The intention was just to ensure that there was no gap there and that we weren't only considering one type of engagement under 7.1 in respect of work engagement for work as opposed to, right.
So are we satisfied that it would cover a contractor or subcontractor in the definition? Ms. Grant?
Yes, sure. I think that how employer is defined, it's broad enough to include a contractor, and given that a worker is defined as somebody who's also engaged under a contract for service, then I don't think the specific reference to the contractor would need to be made in this context.
Are we all satisfied with that?
I still have a niggling, it's sort of, Senator Fraser-Binns, I don't know why I feel like this is one of those things that when we look at it in the Senate, we say, why isn't that in there? Why isn't that clarity there?
Minister, it appears so, you know. But,
well, may I ask, will it do any harm if we included it?
Chair.
Yes, Mrs. Celia Brown.
And the only other way I see we can deal with it is if we include contractor in the definition of employer, and if we define Senator Johnson Smith who a contractor is. Would that make it any clearer, you think?
Oh, absolutely.
That would help. And maybe a contractor or subcontractor.
No, I don't think we should include, I don't know if we would need to include a subcontractor.
A contractor sometimes.
I will look at it and see if we can get any person who engages in any form of worker and includes a contractor, and then we come up with a definition for a contractor.
Okay, very good. Very good, thank you. So I would like to recognize Ms. Grant and then Ms. MP Sibley. Thank you, Mrs. Celia Brown. Thank you, Minister Johnson Smith and Senator Fraser-Binns.
Thank you, Chair, but that was for the point I made just a while ago, so I took my hand down.
Okay. Okay, all right. I think we can, Mrs. McCarthy.
Yes, Minister, just wanted to get from Mrs. Celia Brown a confirmation that we're going to add this new section now for the definition, first for clause 2.
Sorry, Ms. McCarthy. No, what we're going to do in the definition of employer, we're going to amend it so that it includes a contractor, and then we will come up with a definition for contractor, which would cover the concerns that were raised by Senator Johnson Smith and the other members of the committee.
Okay, so I would just add that to the clause 2.
Yes. Yes, yes.
Thank you, Mrs. Celia Brown. SG.
Thanks. Yes, thanks, Minister. Just pointing out that subcontractors are already addressed under the definition of worker, just for the point you were raising.
Yeah.
So it's there in the bill.
Okay, okay, thank you. Thank you. So I think we can now move on, Ms. Grant. I just want to say to members.
Yes. I'm sorry to interrupt, but I just to remind that we had asked the acting director of legal reform, Ms. Wilkins, to look at for us, and I think it would fall under an expansion of this clause 7 with respect to board and board members. Remember, Chair?
Yes. Yes.
So I'm going to locate her now, Chair, and bring her back so she can make her presentation and advise the committee in relation to the LRD findings in that regard.
Yes, Chair. We had agreed.
Chair.
We had agreed that especially in light of the fact that Senator Campbell Rodriguez had raised that concern and she would have been absent during the deliberations, we had decided to suspend or have Ms. Wilkins re-represent her submission today.
Okay, good. So we will take her submission now.
She's coming, Chair.
Right. After which, Senator Gale.
Yes, Chair.
As usual, I will ask you if you could continue to chair the committee and be excused.
What time are we scheduled to go today, Chair?
Until 1:30. But if we can go later, Mrs. McCarthy, I would appreciate that if we could go later. I just have to know. I'll have to make arrangements for Parliament. But this is a report that we have to move on expeditiously.
Chair, I have a challenge because if I can go up to 1:30,
yes,
but at 2 o'clock I have a meeting with the Ministry of Labor. So
okay, that's fine. That's fine. We just have to schedule another meeting because the pace we are going, we will not complete this report today. I can see that.
Sorry, Minister, but I'm not sure that we'll be able to go any further because other members of the House are members of the committee.
Yes.
As well as other issues that might
So we
arise.
go until 1:30.
Yes, Minister.
Right. And Senator Gale, when I slip away at about midday, you can continue for me with the agreement of the members. No
yes,
objection?
Yes,
Madam Chair.
So we'll take the report now. What did you say, Senator Campbell Rodriguez?
No, I was saying I was in agreement with what you're saying, but I will have to leave earlier as I have a 1:30 that I need to go to physically.
Yes. Okay.
So I'll be leaving somewhat early.
Yes, we're going to miss your input. Yes. All right, so we'll take the presentation now.
I may also have to leave in another 10 hours or less minutes. My apologies.
I'm sure members won't leave until they have heard this presentation. Right, at this point by our team. Okay, good. Please go ahead.
Is that for me, Chair?
For you. Yes.
Okay. Good morning, everyone. This is Nadine Wilkins, Legal Reform Department, and thank you for affording the opportunity for us to assist you in looking at this really important issue. We were asked to examine the proposal for board member, sexual harassment by a board member as between one another to be considered for inclusion in the bill. And we were asked to advise essentially on a matter that would see an expansion of the scope of the bill.
Mm-hmm.
The scheme of the bill generally applies to a situation where there's an imbalance in the relationship between the harasser and the victim. For example, the employer-employee scenario, the landlord and tenant scenario, where the victim stands to suffer adverse consequences, and where the victim is constrained to make a complaint for fear of adverse consequences. That is the general context. So the relationship as between board members is of a different nature than that between an employer and employee and the other relationships covered by the bill. And therefore, it doesn't easily fit in the existing scheme. A complete review of the bill will have to be undertaken to determine the changes that are required to be made in order to facilitate inclusion of board members. To extend the scope of the bill, we will have to caution that consideration will now be required to look at the statutory authority that is going to be placed on a board member. What will be the duty on a board member? What will be the parameters of that duty? What are the adverse consequences that we would contemplate in the case of a board member who would have responsibility for ensuring the environment which the board functions is safe from sexual harassment? And what will be the adverse consequences to the victim in such a scenario? We have to think those things through. To whom would a board member make a complaint? We have to think that through as well. And therefore, we'd have to develop a whole different scheme for treating with complaints by board members. We would have procedural steps would also have to be considered and put in for a board member to lay a complaint. We'd have to develop all of that. It cannot be easily integrated into what we presently have. Also, the remedies that are provided for in the bill, some of them may, but they don't comfortably apply. They don't contemplate a board member, and as such, they wouldn't easily be applied to a board member. And then what would be the appropriate remedies in the case of a board member? We'd have to think that through as well. We pose these questions because we want to point out the consideration, research, and policy development that it will require. And, you know, we warn that there's a danger of legislating in the absence of carrying out that background work. We don't want to enact legislation that looks good on paper, but when the time comes, we have difficulty in implementation. This is, and we also recognize too that this may be time consuming. And when we look at our file on sexual harassment, this matter has been worked on since over 21 years ago. Our former director, Dr. Eileen Boxill, there are files of work that she had done over the years on this matter. And there were so many attempts to bring this matter to Parliament. It is of such a long standing that we would really not wish to become this close to enactment and to be delayed by what would be necessary to properly provide for board members. So we recommend, that is the context in which that we recommend that rather than delay the bill, consideration should be given to proceeding with enacting the bill and providing for an earlier review period. So clause 42, that provides for the first review to be in the first 5 years, at the end rather, of the first 5 years, we would recommend that we could reduce that to 3 years. And I think that that period of time is an adequate period of time for this matter to be properly distilled. It may also give an opportunity to look at sexual harassment in more general terms. These areas here, workplace, institutions, accommodations, were targeted as very critical areas because of what was actually happening to people in those situations. But it doesn't mean that it has to stop there. But we're just asking for the work to be done while we allow the bill to go through. And when the review time comes, it is perfect time to look at the experiences that would have resulted from the 3-year implementation period and the research that could be going on in that time. So that is essentially what we have to say, Chair. I want to say that I think that it is very important, and I understand and appreciate why it is the committee would want to know that when it brings this into being, it would have considered all the vulnerabilities that individuals face and would have wanted to ensure that in as far as it can, it provides a remedy. We are totally understanding the spirit of that. It's just that we understand the work that it requires. And would caution that it would delay the bill. And I know no one wants to do that. So we can do the work, but I'm saying, can we do the work over a period of time more comfortably? That's it, Chair. That's it.
Thank you so much, Ms. Wilkins, for your presentation.
You're welcome.
Thank you so much. I'm going to invite members to comment, but just to say to you, we hear what you're recommending. We recognize the depth of your presentation. I know that we still have a concern about leaving out this particular grouping. I don't know if it could be considered. I know if it's in the policy, it has to be a part of the policy guides the legislation. We may have to come up with something like code of ethics that, you know, companies should have or entities should have.
Absolutely.
I open
Absolutely.
I open the floor for comments, but I think there has to be some coverage, even if it's not by legislation. So I see Mrs. Coburn Robinson's hand up, and I would like to, after that, invite Minister Johnson Smith for her comments, and then just open it up.
Minister, I will follow Senator Campbell Rodriguez because she really had the foresight to raise this issue, and I was supporting her. Yes. So I'm happy to speak, but I would love to hear her views.
She has to leave early as well. So I'll take Mrs. Robinson at this time.
But I can speak before leaving, Minister.
Huh?
I can speak before leaving.
So do you want to go ahead then? And I'll go after you.
I'll go after you. I'll go after you, Mrs. Robinson.
Okay. So I am just extremely ecstatic about the sentiments that have been expressed by the Legal Reform Department, because, you know, on our side, we understand exactly how the members feel and wanting to have the bill do everything that you think it should be doing. But there are so many things that have been held up because we have not been able to get to the point. And so the idea of an early review, I endorse that 100%. And I really believe that we should take note and really consider the recommendations that have been made to allow us. There are other things that are also waiting. I had a meeting recently where there is a matter with the Ministry of Finance, and one of the deliverables is that we table table in Parliament the bill, which was already done, but the other part of it is to have it fully approved and adopted. And so that's a condition that we need to meet with the Ministry of Finance, and they're actually waiting on us to get that done. And that's important. So I agree with the earlier review, and that will allow us perhaps to be able to come back to the table quicker and have those other matters resolved. So that's it, Minister. I'm really just happy for the comments, and I really hope we take them seriously. Thank you.
All right, thank you, Mrs. Rob. Yes, Senator Campbell Rodriguez.
Thank you, Madam Chair, and thank you, Mrs. Seeley Brown, for the presentation.
Ms. Wilkins.
Sorry?
Ms. Wilkins?
Sorry, Ms. Wilkins. I am not convinced, I'm sorry, because I think this is one of the more important things that were left out. And maybe I need a bit of clarification, but I have not heard enough reasons as to why it needs a lengthier review than other clauses that we have tried to adjust. If there can be some further explanation of that, because maybe if I understood what's so different about this one, then I could understand it a little bit better. But I'm not sure if because we have some deadlines from the Ministry of Finance or because we may be delayed by a week, it is what we make priority. And it would really be sad if we leave this out and any issues arise, and it's because we never took an additional few days just to sort this matter out. And while I respect the needs of the Ministry of Finance, I respect the needs of agreements we have signed, I also, and more importantly, respect the rights of Jamaicans to be protected from sexual harassment. So I'm sorry, I'm still not convinced. And maybe it is because I don't understand why this clause is so much more harder to look at than any other clause. And I'm open to hearing what it is that makes this one so difficult that we have to leave it alone right now.
Thank you, Senator Rodriguez. We have to lean on our drafters, and we have to listen to them. This piece of legislation is urgently needed. And yes, it's a deliverable based on certain agreements. And, you know, I'm not sure I should use this term, but this is an elephant we have to eat a bite at a time. And so I think we have done quite a bit of work, both in terms of the drafters and you members and those who have been a part of this journey. And so, as Ms. Wilkins indicated, a lot of work has been done and more work needs to be done, and the time is needed. Maybe bringing the review of the legislation earlier, and which would also allow some time for us to look at how we treat with this particular matter. I want to put on the table, if there is a way that we can have as part of our recommendations, not necessarily in the legislation at this time, but find a way to have some code of ethics for the oversight bodies that would take into consideration the kind of behavior that is of concern regarding sexual harassment, among other things. So at this point, I would like to open the floor to ask Minister Johnson Smith to make her comment, because she was the person who really gave a lot of support to Senator Campbell Rodriguez. And I too feel that it's an area that is real, and that although it's not recommended that that is included in the legislation at this time, that we have to put on record that there is a concern. So Minister Johnson Smith, do you wish to make a comment at this time?
Thank you, Madam Chair. And
to put your camera on, please.
Thank you for the reminder. So I agree with Senator Campbell Rodriguez to the extent that I share her question as to why a framework couldn't be built around this particular group, because to my mind, the thinking that the relationship among a board of directors would be analogous to co-workers in terms of them being of the same status, and their service is certainly engaged, albeit not under a formal contract of services, but they certainly would be carrying out work in a capacity for a person conducting a business or undertaking work, which is the umbrella language for the definition of worker. And accordingly, my thinking had been that this could be built out. I had thought that we would contemplate that the company of which you serve as a board would be the employer with the duty, and certainly such a management, the management structure and a corporate management structure could be viewed in that context. But as you say, Madam Chair, we do have to be guided by the drafters, and certainly I wouldn't wish to imperil IDB assessment. And certainly, as we are all agreed, and you just heard Senator Campbell Rodriguez, that the urgency of the bill is clear, and I support you, Chair, in that. But I wonder if a middle ground could be found, perhaps, if the drafters are insistent that I am oversimplifying the process and that we would be much further away, if it is possible for us as a committee to note that we would could perhaps not await the 3-year review and ask that that the status of protection of directors under this act be considered for inclusion under paragraph I of the worker, of definition of the worker, so soon as that conceptual framework could be defined. I don't know if that is if that would suffice, but if it is based on my thinking of the analogy between co-workers and a board of directors who all have an employer, and being the company. The company is the one with the duty to establish the system that protects workers. And certainly you would, reasonably report to the chair. And if it is the chair, then you would report to the CEO or head of HR or something like that. Meaning it doesn't seem to me as complicated, but I am clearly not a drafter. So there's a lot that I could very well be missing. So Madam Chair, my question is whether that could be a solution. That is, we wouldn't necessarily wait for the 3-year, but we wouldn't allow this particular issue. If it is that it would delay us substantively, if it would delay us significantly, I don't know if it is something that could be considered in parallel while we're finalizing the report and all of that, and it's an amendment which could be put by the time the bill comes, because that will be a process as well. I don't know if they're doing the list of amendments at the same time.
We're trying to walk and chew gum.
Understood, Madam Chair. So my aim is just to try to find a solution, because I do think it would be good if, certainly I would have argued, had we not addressed the issue, I would have argued, or have suggested that it be argued before the court if a director had a case or had that they weren't excluded, and I would seek to fit it in under here somewhere. But if it is that the sense is that it would not work, it is not on all fours with the act already and needs more, then I would ask that perhaps it be looked at for inclusion under I, even prior to the 3-year review.
All right, thank you, Minister Johnson-Smith. I see Senator Scott Motley and MP Brown-Burke. And I'm going to, at the same time, hand over to Senator Gale. If you could please take over the chair. And then I could ask Ms. Wilkins if she would want to respond to the comments of Minister Johnson-Smith. So, Senator Gale?
Okay, Chair.
Fine, thank you. Senator Scott Motley, thank you so much.
Thank you, Chair. As you're about to depart, so I address both chairs. I was originally of the view, as the committee would know, that this was not the legislation for board members, which was what Senator Natalie Campbell Rodriguez had raised. And I was the person who attracted the attention by saying, the next thing you know, you'll be saying board chairman. The passion of both senators was such that I was persuaded to change my mind. And so I still feel that the issue has to be addressed in some way. I am grateful to Ms. Wilkins for pointing us in this direction as she has, because her research was obviously quite extensive. And what I felt was that she pointed out that the concept of the board relationships was a bit outside of what it was that we wanted to capture at this time. One of the things that has impacted on me is that in the submissions which we have heard, persons have gone far and wide in making suggestions as to what should be considered sexual harassment. And it reinforces the point of how seriously people take this matter. I believe that in the same way that we had made a note in the joint select on sexual offenses, which I had reason to look back at a few weeks ago, that we made a note of the committee's desire that we could do that in this report, to say that the committee wishes for that to be considered and the best way to deal with it found going forward. Because as I said, the senators were so persuasive that it brought to me the reality which I'd overlooked of those relationships. I want to find out, I put it now, if there could be, in addition to the 3-year review, in which we could probably look at it, if we could make a special note in the report to draw attention to this matter. Thank you, Chair.
Thank you, Senator Scott Motley. Member Brown-Burke.
Thank you, Chair. At the last meeting when I raised the argument, I think you were just leaving the chair and the minister was just taking back the chair. And then we had said that there were some members who were not here who had previously spoken very strongly about the matter. I started thinking that we should, and then I was persuaded by the arguments put forward by the technical persons. And then as the argument continued, I went back to the position that it really should be a matter that is covered and that our board members should not be left out there hanging. And I still feel that way. I'm joined by what Senator Scott Motley said about putting a note in the report to identify what I consider a gap. And so that as soon as we can, a remedy be found for that. Of course, it would mean that we would need to move a little bit more speedily than we have done in the past in terms of moving or improving our bills when we do the reviews and so on. I still feel uncomfortable. I noted what the drafters have said, and in a sense, I understand the issue about the scheme and the concept and the aim of this particular bill. But I just still wanted to put on record that I'm still very uncomfortable.
Thank you, MP Brown-Burke. Any other comment? I am not seeing the hands raised on my instrument with the text up. So I'm asking members to just indicate that if they wish to speak.
Chair.
Yes, Senator Longmore.
Thank you, Chair. I too would want to go on record because I think it's a very critical juncture that we're at. And I share the concerns wholeheartedly of Senator Campbell Rodriguez. But we live in a real world where we have the timelines and we do have a mechanism in place with respect to the review. So I think that it is prudent for us to resolve as quickly as we can and seek to that review process, or as Senator Scott Motley suggested. But I would not want for us to miss that deadline of the full enforcement and provisions for persons out there who need the protections from that this bill offers. So I would hope that we can move forward, knowing that that is the primary objective at this time. It is critical for us to get this in law as soon as possible. Thank you, Chair.
Thank you, Senator Longmore. Any other comments? So we would have colleagues taking the sentiments being expressed. And let me say this in terms of my own views on the matter. The representation made in terms of this matter, I am convinced and would have been further convinced when you actually look at the situation where a board member could be exposed and there is no real remedy as it is now in the bill to give for that protection. I was of the view that, you know, we could have treated with it in clause 3, the duty to ensure the environment is free of sexual harassment, and have the clause 5 also treating with the matter if the matter was raised, if the matter was reported. And I also share Minister Johnson Smith's view around the employer's role in this situation. But I'm also understanding of the sentiments being expressed, the concerns being expressed by those in the final analysis who are the drafters, who would have to make sure that whatever application is placed in the legislation are provisions that can hold together, can make the legislation compact, and can make it not exposed to any challenge. So I'm understanding of the role of the drafters. What it, however, means is that this is one of the areas of concerns that would have been raised that would require the quickest form of attention in terms of how do we treat with it when the bill is passed. That attention would have been given to work on some sort of an application in this regard, so that there is still the preservation for the protection of all that would have been exposed in terms of the scope of this legislation. So we can agree, therefore, that the report would somehow capture the sentiments that would have been expressed by not only members, but by the technical team in this situation.
Chair, may I?
Yes.
Yes, I just wanted
Ms.
to.
Wilkin.
Thank you, Chair. I just wanted to respond to make it clear that we're not just talking about a drafting exercise. If it were, Mrs. Celia Brown is a brilliant drafter. She would do it if it were so simple. It is really is more. In order for the drafter to work, we as the researchers and the assistants in developing the proper framework and policy around it, we would have to get to work and we would have to provide her with that information from which now she could do a draft. And the point we want to make is that it would take time. We want to do it properly. The truth is that sexual harassment is more pervasive than even the boardroom. You have familial relations where sexual harassment may arise. So there is more work to be done with sexual harassment. And we certainly endorse that and would certainly offer ourselves to assist in any way that we can in furthering this matter. But we really must say that time is necessary to do the preparatory work so that it can be done in a way that it can be implemented properly. Because one of the dangers of rushing is that you put something in and when it is time for it to be implemented, the proper framework isn't there and it inhibits the effectiveness of it. So this is in the spirit and against this background that we have made the recommendation that we have made. And yes, it is a lot more than a drafting exercise. Thank you.
And thank you for your intervention on both days.
It is my pleasure to assist, Chair.
Thanks. So, colleagues, with that being said, can we Can we agree that this is the approach that we're going to take? Members?
Yes, I support it, Chair. It is clear that the policy work, well, we're being advised that the policy work is such that it would require significant delay, and that there is a commitment to ensuring that the policy work is properly done and not rushed, so that it is it's appropriate for inclusion. So I am supportive. While I had suggested a particular way in which the committee could note our desire for it to be addressed as soon as possible,
yes.
I haven't heard any member support it, so I presume it will fall by the wayside, and I will therefore just support that the committee clearly propose that the inclusion of board members in an expressed way in the legislation and an appropriate framework for treatment with board members be introduced as quickly as possible. And
just remember, thank you, Minister Johnson, but just remember that so we are going through this review on these deliberations today. But I'm sure in my mind that this discussion will once again raise its head when the bill gets to Parliament. And one can never underestimate if and when that matter is raised, what could be a possible resolution. So I will just say that.
Thank you, thank you,
Chair.
Chair. Oh, sorry, I think.
Well,
if I might just finish my comment, Chair, just to say that certainly if it is possible for the policy work to continue in the event, if the line ministry, of course, would have the capacity to support the policy continuation of the policy work on its inclusion, subject to its while we work towards tabling in Parliament, then that is something that the committee could encourage. But I think the general sense is that this particular issue should not prevent the tabling of the bill or its passage in Parliament, but that it is a matter that the committee believes must be dealt with urgently for its inclusion.
Expeditiously, yeah.
That point is captured by and that it should not necessarily await the 3-year review. And I suspect that the committee is in agreement with the 3-year review, which was a separate proposal as well. So instead of the 5-year, so I haven't heard any objection to that expedition of the review. So perhaps that could be noted as well. Thank you.
Agreed. Thank you, Minister Johnson-Smith.
Mr. Chair, my hand is up. I'm not sure if you can see the hands.
No, I can't see it, so go ahead.
Okay, thank you so much. I just wanted to ask, is it Ms. Wilkins who presented?
Yes.
Ms. Wilkins, the suggestion by Minister Johnson-Smith as to how we could deal with it now, what was the reason it could not be done in that way?
I'm sorry, I'm not sure. I heard you clearly a while ago. Your voice kind of went off.
Okay, let me try speaking a little louder. I was saying the suggestion made by Minister Johnson-Smith, what was the reason that could not work? I'm not sure.
We were saying, that was explaining that it would require more than a drafting exercise. That was why I was making the point about the time that it would be necessary to develop the framework. But I should also point out that what has happened in the past and has proved very useful is the development of policy guidelines. We don't have to wait until the legislation is in place to provide for the board member scenario. Policy guidelines can be developed. They can be produced. They can be promulgated. You can get the message out in that way, and at the same time, it doesn't prevent it later on from being captured in legislation. So we certainly would assist in the development of those policy guidelines if the ministry so requires.
And you're saying, Ms. Wilkins, that the development of any such policy guidelines may very well accelerate towards having the proper insertion in our future legislation?
We're having some connectivity issues. I'm not hearing at all, Senator Gale.
Oh, I was saying.
Oh, I'm hearing you now.
I was saying, if the development of any such policy guideline, do you believe that that may help to accelerate these provisions in the bill, in a legislation?
Definitely, sir. Definitely. It is something that will go a far way in our view.
Okay. All right. Thank you. So, Ms. Mark, I gather, and Ms. Grant, I gather we can agree on the approach to go forward with all that would have been recommended, and that such is recorded in the report.
Chair, I will have to seek clarification from Ms. Grant after the meeting has ended, because I lost connection for about half an hour. So.
Oh, okay. All right.
Sorry, Chair. We are assume, Chair. The guidelines.
Yeah, Enrique, Ms. Grant?
We're agreeing to the policy guidelines, Chair.
We would agree to the submissions on the concerns that would have been raised by members, and also supporting as in addition to the policy guidelines. But I would want the report to reflect the sentiments being expressed by members.
Very well, Chair.
All right, we can move on now in terms of the text.
Right. So, Chair, if I may, I just had a conversation with the Minister.
Yes, Ms. Rob.
Right. And
yes, sure.
In response to the concerns that were raised about, persons being concerned that if we proceed, some areas that they wanted to have addressed might not be addressed. So one of the things we discussed is that read the Code of Ethics. We could perhaps, as a bureau, work with our gender focal points. We have some gender focal points in ministry departments, agencies. We also have focal points in private sector. And so we believe if we make an overture in terms of just having a conversation with them, I don't think they would be averse to working with us to develop a code of ethics. The other option could be perhaps a consultant, because we're going to have a consultant to assist us to build out how the tribunal should look, because this is going to be the body with extraordinary powers and so on. So that's something we could consider. So Minister has asked me to share that with the members to see how that sits with persons. Thank you, Chair.
Thank you. Thank you, Ms. Rob. Any comment on that, colleagues?
Chairman.
Yes, MP Brownberg.
Chairman, I like that approach, especially if that is twinned as well with the policy, with an inclusion in terms of the policy guidelines. That also makes that clear.
Okay.
But I believe it really is important. And again, I go back to saying that I understand what the technical persons have said. I understand it, although I feel uncomfortable moving on with us without it. So this would certainly make me much more comfortable, knowing that the policy guideline would include that, and also that there would be that kind of active collaboration between the Bureau and those who this is intended to serve, to move in that direction.
Noted, MP Brownberg. All right, Ms. Grant, we can proceed.
Yes, Chair. What is on the screen is where you would continue
Okay.
from.
We note the proposal that if the bill is aimed at creating a safe environment for all workers, it should extend the context of and protection from sexual harassment occurring in other directions. That is, a worker harassing a supervisor or manager, as well as colleague to colleague on the same level. Your committee accepts the recommendation, agrees to a standalone provision to protect an employer, supervisor, or manager from being sexually harassed by a worker. It further went on to say, Clause 7, sexual harassment by an employer, supervisor, or co-worker continued. Your committee notes Clause 7.6 and the use of the term complaint or claim in bracket, and the proposal for a review of the clause to ensure consistency in language and to ensure the policy intent is captured. Your committee accepts the recommendations for consistency in the language and agrees to delete the words in quote or claim in the third line of Clause 7.6. So we can move on to Clause 8, sexual harassment at an institution. Clause 8 addresses sexual harassment at an institution. It was proposed to expand the scope of Part 3 to clearly address sexual harassment between/among individuals enrolled in an institution as defined by the bill. Your committee does not accept the recommendation and agrees that no change should be made at Clause 8. We note the observation that the scope of the legislation is too narrow, mostly dealing with institutions and workplaces. We note the proposal for the scope to be unlimited, with an emphasis placed on specific settings, namely workplaces, institutions, tenancy, churches, clubs and associations, sporting activities, vendors, receipt of goods and services. Your committee does not accept the recommendation to expand the scope of the bill in the manner proposed. It was noted that the definition of institution is sufficiently broad and includes, for example, a place for the use of any facility by members of any organization, end quote, and, quote, such other places or facility as the minister may by order publish in the Gazette designate as an institution.
Chair?
Yeah?
Sorry
that is
to interrupt.
Seeley Brown. Sure. Go ahead, Mr. Seeley Brown.
Chair, in my notes in relation to Clause 8, I have that we had agreed that we were going to expand the scope of the bill to deal with student-to-student sexual harassment. So I would like for the other members of the technical team and even committee members to check, Chair, because that is what I have. I have a note here that it must deal with student-to-student instances of student-to-student sexual harassment, which will not be what is stated in the recommendation in relation to Clause 8, Chair.
Was that the era that we spoke about, the age?
Well, no, we did say that it would not apply to persons on the specific age, but we also said that you needed to treat with sexual harassment in an institution where a student of whatever age was agreed sexually harasses another student. At least that is what I have in my notes, Chair. I don't know if Ms. Grant can assist.
Oh, but Chair, if I may,
yes,
you're
Ms.
correct
Aldred.
that the discussion of the age in a way overtook some of that. So what I think the committee, well, I thought there was agreement, but at least I know the discussion then morphed into, for instance, a 17-year-old harassing another 17-year-old, because remember now there's going to be a provision that says that the bill does not apply to persons under 16, but you do have persons who are 17 and 18 who are, for instance, in universities and on campus. And I'm just picking a university as just one example of an institution where it is likely that you can have this type of interaction, because this was part of the discussion, and that's why I'm highlighting it now. And so it was raised, I think I'd made a point, Mrs. Masada had made a point about what about, say, two 17-year-olds or a 17 and an 18-year-old, for instance. So that I remember that discussion morphing into the whole issue of the age as well.
Right. And I remember the discussion around the, I mean, I can't recall who had represented it, but around the 17-year-olds at the university level. So,
Right,
so
and
how do we?
I'm raising that because you see they would be students. So you
Right.
could then potentially have student to student
Harassment. So how do we do the insertion now in terms of representing that?
Well, it's just to ensure, Chair, sorry, it's just to ensure that it was agreed. What is reflected in my notes was agreed that it was recommended that a provision be inserted to deal with sexual harassment among between a student and another student.
Okay. So committee members, we can agree on that? Members?
Yes, Chairman, we can agree.
I'm in agreement, Chair.
Thank you very much.
I'm in agreement, Chair.
For a moment, I thought there was a break in transmission.
Never, Chair, never.
So we can now move on to clause 8.
It's clause 9, Chair.
Clause 9, sorry. Sexual harassment in relation to accommodation. Clause 9 addresses sexual harassment in relation to accommodation. Your committee notes the proposal to include provisions addressing the following matters in clause 9, but does not accept the recommendations that sexual favors should not be suggested or requested in lieu of rent, bills, or repairs to the property. Landlords shall not utilize technological instruments such as camera to spy on their tenants or invade their privacy. A landlord should not seek or a tenant offer sexual favors for the continuation of a tenancy agreement. And a landlord who may have personal information, quote, relationship status, financial status, occupation, work situation, etc., about a tenant should not use the knowledge that he had to exploit the tenant for sexual favor. I guess this was submitted by, it went on further. Landlords who have keys for the tenant's dwelling should not use it as an opportunity to enter the dwelling in pursuit of sexual favors. Landlords who have keys to their tenant's dwelling should not use it as an opportunity to enter the dwelling in pursuit of sexual favors. A landlord should not exploit a tenant's vulnerability, loss of employment, loss of spouse, loss of financial support, etc., for sexual favors. And special provision should be made for children in residential accommodation for complaints to be made on their behalf. Your committee recommends that the amendments be to the Cybercrimes Act and or Sexual Offences Act to make the utilization of technological instruments such as cameras to spy on tenants, which invades their privacy, a criminal offense. It was agreed that such matters do not fall within the remit of this piece of legislation. Well, that was specifically speaking to, go back to that last point. Okay. All
This
right.
is
So we
Chair that you want to go back to.
Yes, Ms. Grant.
Chair, it's Mrs. Seeley Brown.
Oh, Mrs. Seeley Brown.
Chair, I don't like the way it's written. This paragraph is written because it is not that we don't act. It wasn't my view that the committee did not accept the recommendation that these things should be dealt with. It's just that the committee agreed that this legislation was not the appropriate piece of legislation to deal with it. But when you read it, Chair, especially where it says your committee notes the proposal to include provisions addressing the following matters in clause, but does not accept the recommendation that, and you list all these things, it kind of implies that you don't agree that these things should be done, but it's not that. I think is that the committee was saying we understand these issues, but we don't think that the sexual harassment legislation is the appropriate legislation to deal with it. So I would just like us to just, just change the chapeau, Chet?
Yes.
Chair? Yes. And what we have in recommends that amendments need to be made. I think we can bring that up further, Chair. So rather than say that your committee does not accept the recommendation, that you note the concerns raised below, and the committee recommends that amendment be made to the relevant, I wouldn't put the relevant legislation to make utilization of whatever, as it does not fall within the remit of this piece of legislation.
You got that, Ms. Grant?
Georgette, you got it?
That would be Mrs. McCarthy, Chair.
Sorry, Ms. McCarthy.
Ms. Mack.
Chairman.
Yes, Minister Johnson Smith.
Thank you, Chairman. And I'm back online now. Sorry, I had a brief JPI slash flow incident. So just on this point, I agree with the rewording. But to ensure that it's quite clear that the committee's position is that these matters must be addressed, but through other legislation. I wondered whether, is it that we're not at a stage that it should be, that we can more expressly say that it should be included, that these matters must be addressed by the, with the current amendments now being contemplated under the Sexual Offences Act or the Offences Against the Persons Act. The cybercrimes is under a joint select committee now.
Yes.
But the technical teams are actually finalizing the amendments for proposal to cabinet in respect of the Sexual Offences Act and the Offences Against the Persons Act. I know that the matter of stalking, etc., and cyber stalking, that is being done under the Offences Against the Persons Act. So but I take the point. I understand why rather Mrs. Seeley Brown would say don't name the legislation, but I wonder if we lose the opportunity to be more specific about the work that needs to be done and its urgency. If we don't name where it could be undertaken, or at least make a reference to the legislation currently being considered for amendment, more particularly the Cybercrimes, Sexual or Offences Against the Persons Act, so that we can be clear that what we are saying as a committee is that these matters should be folded in. If they are not already addressed, and I think parts may be, but if they're not already addressed in those pieces of legislation, that they should be included therewith or therein. I think I would ask that we consider some language that makes it clear that the committee wants them dealt with promptly and folded into the current legislative work underway.
I agree with you. I agree with you on the point, Minister Johnson Smith, where these would have been concerns raised. And since those other legislations are in scope for review, then it would inspire some confidence that our recommendation would be directing exactly where they could be placed. Correct?
Yes, Chair, that's my suggestion, and I would be interested in the views of the technical team on it, and of course the members of the committee, and because I think it will also help give the public confidence that we have a clear mind as to how it is and when it is they should be addressed.
Yes. Comments? Members?
Sure, I was actually going to wait on the drafters and technical persons, because I had raised this very same point before, and I remember the argument for the generalities. So I'm listening.
Mrs. Seeley Brown? Any response?
I'm okay with naming the legislation, Chair. It's just that I know based on my work and my relationship with the LRD, I think stalking, the way that stalking is going to be proposed is going to be, from what they recommend, is a separate piece of legislation, and it may not necessarily be an offense that is created under the Offences Against the Persons Act. But I don't have any issue with, because we're reviewing the current pieces of legislation, the sexual offences and the offences against the person, in including them in the report, Chair.
All right, thank you. Any other comment?
Mr. Chairman, if it is, I was waiting to see if Mrs. Brownberg was going to come back in, but if she's not,
no, I couldn't stop laughing for a moment.
Oh, okay.
Which is why I had not come back in at that time. No, I'm in total agreement with you, you know. And even despite what Mrs. Celia Brown says, for example, I believe that we need to indicate where we think it might go. And if in fact it might not, and it might need, then even that too could be included. When I read the reports, like even the sexual offenses, the report that we had on those bills that were done, the recommendations in terms of dealing with them were so vague that if you were not a member of the committee and if you had an interest, you probably wouldn't even know where to begin in terms of where to look. And I believe that if we have had the discussions, we have ideas of where it could go, and even including that it could be a standalone bill, that those things could and should actually be included. I really do believe that. To make it seem to others who are reading who are not probably following, because remember, we're not just writing for ourselves, we're also writing for a future generation. It could be somebody who wasn't around when the discussions were taking place and wanted to see what we were doing and what we were talking about. They would have had no idea that these were some of the things that we would have contemplated.
Thank you, MP Brownberg. You know, one of the things, you know, we'd be surprised to the extent that these deliberations are being followed and the extent to which people raise concerns and seek clarity in terms of what is being represented here. And for those who would have taken the time out to make submissions and apply recommendations to be included in the legislation, I believe they too also would be wanting to hear from us how we would treat as a committee what they have represented. And so it ought not to be vague in nature, but ought to be somewhat clear in terms of our response. Soldier?
Yes, thank you, Chair. In fact, I hate doing this because I don't like wasting time. I'm going to repeat a little bit of what Senator Brownberg actually said, because I was going to recommend a change in the wording in the report. So there are times when it's better not to actually recommend amendments. I think what Mrs. Celia Brown was saying, better not to say you recommend amending certain pieces of legislation, but I think usually the wording is usually along the lines of consider amendments then, and you would list them: Cyber Crimes Act, Offences Against the Person Act, Sexual Offences Act, as well as whether there would be the need for discrete legislation. Sometimes when you say someone must amend something, a ministry may get that instruction and feel it ties its hands when they realize that it's better dealt with in another manner. So rather than give that very specific instruction, it would be better to couch it in language to say that consideration should be given to trying to address these issues in perhaps either the cybercrime, sexual offenses, offense against a person, or maybe even other discrete legislation.
Thank you for that, Ms. Aldred. And it certainly was not wasting time, but to bring clarity and to reinforce an approach that we can always utilize going forward. Yes.
May I share my concern? I'm completely guided by the SG, but I just want to raise my concern on the flip side of the coin,
yes,
which is that the report would use language which would mean that when we follow up, we hear, well, cybercrimes is MSET, sexual offenses is justice, and offenses against the persons is national security, and no ministry has been given instructions to CPC as to what they are to do, and therefore nothing has been done. That's really what I was trying to avoid, that we would at least narrow what is to be done. So if it is
so I have a suggestion to address that then, Minister.
Okay.
Which some and the some meaning Miss Wilkins will not like, but to deal with matters that are cross-cutting several ministries, sometimes it's better to ask for the Legal Reform Department to lead the charge, or Ministry of Justice to lead the charge. And that can be done. You can ask for that because you know that it will go across several ministries. But some research still has to be done. And so that can be led by Legal Reform Department / MOJ, which has happened in the past. So at least it's not just left just out there.
Thank you, Soljen. Point taken, Minister Johnson-Smith. Thanks.
Agreed. Thanks, Mr. Chairman, for allowing me to intervene again. Thanks.
So what is the agreement now? That we rewrite this the way it's done?
Yes, that's certainly there, Mr. Chairman.
Chair,
yes, MP Brownberg.
I like where this discussion is going. You're trying to determine exactly what we have agreed on here?
Yes.
Is that what it is? Okay,
yes.
Well, let me allow that, and then I wanted to make a comment.
Right. So Mrs. Seeley Brown.
Yes, Chair.
In terms of the approach, you're having listened to that, what would be your recommendation now?
No, Chair, I have no difficulty with what is suggested by Senator Johnson-Smith, and then as Mrs. Aldridge said, you add and any other discrete legislation just to ensure that if other legislation is contemplated, it's captured. I have no issues with that, Chair.
Okay, all right. MP Brownberg?
Certainly. I just wanted to ask, Chair, if having agreed on that, and I mean, I think it captures the sentiments quite well, whether or not we're going to look back on the recommendation we're actually making as it relates to stalking, street harassment, and that kind of a thing. And then just to be clear, I raise it because, as Ms. Aldred had said, when I asked a question around that one, we named nothing. For that, it was relevant. I don't remember what we put, quite frankly,
No,
but we did not name anything. We did not name a bill.
Yes.
No.
Yes, we did, Mrs. Brownberg. We had said the Offenses Against the Persons Act because Senator Longmore had raised it too. And that was, or you're saying in this actual document, but I remember being at the meeting where
in this actual document, as we were going through.
Oh.
When it was asked, I had indicated because I had seen the draft clause. So what Mrs. Seeley Brown has just indicated about there being consideration of another approach, I wasn't aware of that because I've seen the draft provision and the draft recommendation.
As we were going through the report, I had raised the matter again as we were going through the report. And so that is what I was.
So what you're saying, MP Brownberg, is that it has not been captured in terms of a direction in this report.
Correct. And I missed a couple of meetings. So I might have missed a discussion with Senator Longmore. So I'm not attributing where it was. I'm just simply saying that the document as is, I would love to make sure that that particular point around street harassment, because I think a couple of us have had the same concern that is addressed in similar manner as we have been discussing just now.
I would have written.
Chair, this is Nani Wilkins again. I just want to interject that we have substantially gone. We're almost complete in the development of a policy paper. We've even done a possible draft cabinet submission. We've done a sample bill as to how it would look. We've done a complete document on stalking. So whatever you decide to do, much of the work has been done by us. We're in fact prepared to send the document out right away for comment. So I hope that would be helpful to the decisions that you make.
Extremely helpful, if I could, Chair, extremely helpful, except that this particular document coming out of the deliberations of this committee, I believe, requires a particular statement from us around it. And as was said before, I'm clear that I'm not the only person who would have said that. And I think that it can only reflect the discussions we have had.
And so you would want the report to reflect such?
Yes.
Yes, it is because the committee had early in the day raised concern about stalking, that we accelerated our efforts.
Wonderful, wonderful, wonderful.
Great.
Wonderful.
That's good. That's good. All right, thank you, MP Brownberg. Ms. Grant?
Yes,
Ms. Mack?
Chair, moving on.
Sorry,
now.
Ms. Mack?
Yes, sir.
You have your hand
That
up.
there is a section in the report at the end that speaks at the consequential amendment section that speaks to street harassment being treated, consideration being given by the ministry with responsibility for sexual offenses, against a person to provide for it as a criminal offense. So I'm not sure if that would address the concerns that Member Brownberg has.
Can we then wait until we get to there so that we can all see how it is represented? All right. This is where we are now, Ms. Grant?
Yes, Chair.
Part 4, designation of authorized officer. Clause 10, designation of authorized officers. Clause 10 authorizes the minister to designate certain field officers in the Bureau of Gender Affairs as, quote, authorized officers to act as investigators of complaints. We note the proposal to include rules to guide these authorized officers, as well as to inform the complainants and alleged harassers of their roles. Some of these rules need to address A, the confidentiality of the investigation, B, the responsibility to interview both complainant and the alleged, C, presenting an alleged harasser with a written document containing details of the complaint against him or her, D, separately interviewing all witnesses, E, taking appropriate notes and written statements, F, collecting and reviewing all documents concerned, and G, preparing a written report for the tribunal. Your committee does not accept the recommendation to include the rules as proposed in clause 10, as the rules should be made in relation to the tribunal and not the designated authorized officers. We also agree that there is no longer a mechanism in the legislation that involves the minister or the ministry as it relates to clause 10(1)(b). Accordingly, we agree to delete clause 10(1)(b) and 2, add provisions to further, what should that be clarified? I'm not seeing that, Ms. Grant.
Yes, Chair, clarify the.
Sorry?
It is clarified, Chair, to further clarify.
Okay.
Oh, you're not seeing the rest of it?
No, I'm not seeing the rest of it.
to further clarify the role of D, and I'm going to switch now.
Right. The role of the designated authorized officers to ensure that clause 3 and 4 of the bill are properly observed. We agree further that provisions should be included for the specific powers of the designated authorized officers to enter premises to undertake their inspection, among other things. Your committee also notes the proposals to amend clause 10.3 to make the period of compliance with the direction of an authorized officer to read not more than 30 days. Your committee accepts the recommendation and agrees to amend clause 10.3 to make the period of compliance to read not more than 30 days. So I guess we can agree on that. Clause 10, designation of authorized officers, continue. Your committee also notes the proposal to amend clause 10.4 to significantly increase the maximum penalty to more than 1 million for an employer in breach. Your committee does not accept the recommendation for the penalty for failure to comply to be increased in this clause, but agrees that the clause should remain as is. So what is there? Your committee also notes the observation that the Act does not highlight criteria, selection process, performance monitoring, or communication with the public on performance of the tribunal, and that the suggestion that there should be a maximum turnaround time for cases to be heard and decided on at the tribunal. We note the proposal for both the tribunal members and the authorized officers who support them to be trained and certified in matters pertaining to sexual harassment, gender awareness and sensitivity, diversity and inclusion, and intersectionality. Your committee does not accept the recommendation. So these would have been parts of discussions that we would have had, correct? Ms.
Yes,
Grant,
sir. Yes,
in terms
Chair,
of what
yes.
is contained. So what are we supposed to do here?
Either say that the committee accepts or does not accept. Yes, that's why it's in red.
Committee members?
Okay.
Committee members?
Mr. Chairman, I just have a question as to whether the issue of training, generally training and certification is a matter which had been discussed in the context of recommended best practices or guidelines or guidance that we were to be providing. It just seems that that I recall the issue of training existing. I mean, us having had the discussion of training, if not certification in these matters. But I can't recall exactly what we had, what the discussion concluded.
Chair, through you.
Yes, Senator Longmore.
Thank you. Yes, I recall the discussion, Senator Johnson Smith. I think the final conclusion was that it was recognized that such training would be necessary, but it would be more along the policy rather than having to be legislated for. I think that was the gist of the discussion that we had.
That was the context.
Yes, I think so. Thank you.
So yes,
and
Minister
Chair, sorry.
Johnson.
Sorry, Chair, I have to leave in about 2 minutes. My apologies.
Are we still having a quorum?
Good question, Chair. We should do a quick check.
Unless you're going to do a roll call, Senator, I'm thinking we're losing quorum.
Yes, I see we're losing quorum.
Yes.
So we still have Minister Johnson Smith. We still have MP Brownberg.
I'm not seeing her. I'm not seeing her, sir. Are you seeing her from your side?
No, I can't see her from my screen.
I'm not seeing MP Brown.
No, she has fallen off. She has fallen off. I see Minister. I see you, Senator Gale. I see Minister Chuck on. At MOJ, Senator Longmore, myself, but that's it.
And so what would be quorum? Again, Ms. Mack?
It's 4 plus the chair. Four including the chair, sorry.
Including the chair. And we go. Yes. Senator Longmore is leaving in 2 minutes. So that leaves
1 minute now.
So that leaves Minister Johnson Smith and myself.
Yes.
Senator Delroy Chuck here. I have to leave to head out to Parliament shortly.
Okay, so it sounds like, Chair, you have to wrap up now.
So in that case, the fact that we're losing quorum, Ms. Mack?
Yes, sir.
So we leave on this note because we really have to come back to this. But when is the next possible date?
That's going to be a challenge, sir. But we'll have to talk about it outside of, yes.
Yes. All right. So colleagues, in light of this,
Chair, sorry.
Yes.
Yes, Marlene Aldred.
Yes, Aldred.
I'm wondering, I'm making a suggestion. It's laudable that the committee wants to just read through the report, but you do realize the pace at which you're moving. So I don't know if maybe the committee members can be urged to read. I know Mrs. McCarthy sent out version 3, and then maybe what you can do is another approach going forward to try to move the pace on a bit. I was going to suggest something else, but I think part of the problem is there are still a number of unsettled issues. So I would suggest that maybe those would be the ones that you would highlight and bring forward when going through the report in the future. Just a suggestion to try and improve the pace.
So we can look at that and just pull out the gray areas, or let's say the areas in red, which would have been the areas of concerns. Because all other areas, apart from any, error that can be corrected, we would have understood and would have agreed on. Because I had the same concern in terms of going through an area that we would have already agreed on. The committee would have already agreed on it. So let's just pick out those areas in red and let us deal with them. And Ms. Mack, maybe you can have a conversation with Minister around this approach.
Yes, I would support that, Mr. Chairman, and what could be done is a mail could just be circulated, given that this decision or this recommendation is being made at a time that most members are absent.
Yes.
So once a discussion has been had with Minister Grange, a mail could be circulated to indicate that in order to move things forward, it is being proposed that we take an exceptions approach. So all members are asked to read and focus their minds, or rather address their minds on the outstanding issues, and to be prepared to discuss those issues at the thing. And if anybody has any recommendations to be made in terms of amendments to the report, which they believe have not otherwise been addressed, that they can otherwise indicate, but that we won't be going through in all. Yeah.
Agreed approach, Minister Johnson Smith.
But I also have one massively important issue, sir, to raise, if Ms. McCarthy would permit me. And that is that at the opening of this report, my name is not present as a member of the committee. So I ask through you, Mr. Chairman, if that could be corrected unless a change in my status has occurred, of which I have not been advised.
And we would not have been aware of. So, Ms. Mack, you have that?
I'm not certain. Please indicate to me again, Senator, what you're speaking of.
Let me find the page.
Page 1.
Yes. Sorry, I have to look at.
I think I recall.
Page two, Mrs. McCarthy.
I'm taking it from the motion that was done in, but I will double check to see. I was.
So
yes,
I recall a motion
and also
was done
page
for.
3.
Okay.
Yes, the motion. Sorry, the motion was absolutely passed with my name in it, Ms. McCarthy, and chances are I'm even moved it myself. But it is I should be listed. Thanks.
So the report does say that, Minister, that you moved it, but it's just that in listing the names, your name is missing.
Right, that's it. I think when you moved it, Minister, it was your and Senator Fraser Binns who were included.
So just a correction, if I may. The committee had this bill had 2 committees. And that's how I started out in a chronological manner by naming the first committee that was named, and then Senator Johnson Smith, was added. That's why it's there as that in that manner. Unless it is that I would just indicate this now committee instead of indicating the chronology of the members.
So you would have to indicate. So since
it's
a
on
new committee.
So I think, Chair, the issue that Mrs. McCarthy is raising is on page 3 in the 3rd paragraph. In the 3rd, be it resolved that the names Kamina Johnson Smith and Sophia Fraser Binns be added thereato. So it's in that 3rd paragraph on page 3.
Okay, I've
but
located
it's not in the list of names. So
okay.
I don't know if there's another way that it could be done.
Which is what
Mrs. McCarthy was sort of suggesting, perhaps.
So maybe since you would have had additions to the committee, then you just have another listing of all the committee members.
It is there, Senator.
It is there?
Yes. I will double check because I will fix it, but I didn't want to bring confusion because initially when the committee was named, Senator Johnson Smith and Senator Fraser Binns were not included on that first list.
On that first list?
Yes.
Yes,
so the addition would have created a new list.
Yes, which
and if the addition would have created a new list, then maybe for the ease of reference, we just have capturing that new list and what that new list represents.
Okay.
All right.
And Chair, if you don't mind, if I would be allowed just to clarify my proposal, it's not that I'm saying everyone should not read the report. I'm saying everybody should read the report in their own time and then come to discuss.
I thought that's how we understood it. But if you further
some comments have been made to me, so yes.
Oh, if you would have further reinforced the position and agreed. We agreed. All right, colleagues. So at this point, motion for adjournment.
So moved, Mr. Chairman.
Thank you, Minister Johnson Smith. I guess we lose quorum, so we can just terminate until the next. Sir. So you'll notify us, Ms. Mack, and you will send out the email communicating what the direction would be, so that all other members would be aware.
Yes, sir.
Thank you very much, colleagues.
Afternoon, Chair.
Afternoon, and stay safe.
Afternoon, Chair. Thank you. And
thank you.
And take care, everyone.
Thank you. Thanks, everyone.
Bye, everybody.
Bye. Thanks again. Bye.